Good morning, everybody. Thank you all for being here. The meeting will come to order. I note that a quorum is present, and I also note for the subcommittee that Ms. Shalala of Florida and Mr. Keller of Pennsylvania be permitted to participate in today's hearing with the understanding that their questions will come only after all members of the Higher Education Subcommittee on both sides of the aisle who are present have had an opportunity to question the witnesses. The committee is meeting today in a legislative oversight hearing to hear testimony on, and I quote, broken promises examining the failed implementation of the Public Service Loan Forgiveness Program, unquote. Pursuant to Committee Rule 7C, opening statements are limited to the chair and the ranking member, and this allows us to hear from our witnesses sooner and provides all members with adequate time to ask questions. I recognize myself now for the purpose of an opening statement, and welcome again to all of you. We thank you for being here, as well as our next panel. This morning, we are here to examine just what went wrong with a certain program, a program that many of us on this committee hoped would act as a catalyst for young people to channel their expertise towards serving our nation. This program's goal was to steer talent into the public sector, particularly in healthcare and education, with the reward of loan forgiveness for 10 years of their public service. I'm talking, of course, about the Public Service Loan Forgiveness Program that we call PSLF. Again, I would like to thank our witnesses who made time to be here today. I must say that we are disappointed that the CEO of the Pennsylvania Higher Education Assistance Agency, known as PHEA, the sole loan servicer charged with implementing these programs, declined our invitation to testify. While I understand the problems with PSLF does not lie with this entity alone, I don't understand why a taxpayer-funded loan servicer would turn down a request to present their side of the story. If PHEA believes the problems with the PSLF resides with the Education Department, then this would have been their opportunity to state that clearly and publicly. In 2007, Congress created this loan forgiveness program, PSLF, and since its inception, we have seen an influx, tens of thousands of citizens financially able to dedicate their lives to public service. And this includes our nation's teachers, our first responders, service members, and many, many others, healthcare professionals included. These American-made life-changing professional and financial decisions made based on the promise that we made 12 years ago. And unfortunately, as a result of the failure to adequately implement this program, thousands of active public servants have been denied the benefits originally promised. 10 years since the passing of PSLF, when the first wave of eligible student borrowers applied in 2017, only 96 of 28,000 applicants received loan forgiveness. That's a 99.6% denial rate. That doesn't make sense to people. A 2018 Government Accountability Office report on this program identified a critical breakdown in communication between the Education Department, loan servicers, and student borrowers. It recommended the department make 4 critical reforms to the program. First, the department should provide loan servicers and borrowers with comprehensive information about qualifying employers. Second, the department should issue a standardized manual for loan servicers. Third, the department should standardize payment information for loan servicers. And finally, the department should ensure borrowers receive sufficiently detailed information to help identify potential payment counting errors. While the department agreed with all these recommendations, it has yet to fully implement any of them, nor have they provided a timeline for doing so. In response to the extremely high PSLF denial rates and understandably widespread confusion among frustrated borrowers, Congress created the Temporary Expanded Public Service Loan Forgiveness Program in 2018. We appropriated $700 million to the Education Department with clear instructions to simplify and expand the program to increase rates of loan forgiveness. Earlier this month, however, the GAO released another report And this time they analyzed the expansion. The GAO found yet again that ED was denying 99% of the new TEP PSLF applicants. Of the 53,523 student borrowers who applied, 661 were approved. So our goal here today is to collectively make it easier for the public servants of this country to take advantage of a promise made to them back in 2017. And as sometimes happen, of course, people are going to search for blame. And in fact, there are plenty of folks who actually didn't produce and do what we wanted them to do, what the American people expect of them to do. But we want to solve this problem. And that's why we're delighted that you all are here before us today to help engage with this discussion. And we would hope that everybody who's connected to this has an opportunity to listen to what you have to say as well. The executive branch's implementation of this law, which was supported by both Democratic and Republican administrations, have not lived up to its standard. That's why I encourage my colleagues in Congress from both sides of the aisle to come together today and offer positive solutions. Today, while we plan to ask tough questions on precisely what went wrong, we also wish to present an opportunity for the Department of Education to initiate a publicly good faith effort to finally implement PSLF program correctly. PSLF is a popular bipartisan program that is critical for ensuring communities everywhere in the United States have access to education, to health care, and other fundamental services. We know that President Trump's own Defense Department agreement with this sentiment, that the department agrees actually with this sentiment. It was under Secretary Mattis that the Pentagon stated, the Public Service Loan Forgiveness PSLF program, and I'm quoting here, has been an important recruitment and retention tool for the military to compete with the civilian sector, predominantly in specialty fields such as the Judge Advocates General Corps, for whom graduate degrees are required, unquote. So that's why we're here today. We're here to look for answers on how we can better support the thousands of public servants who support all of us every day. We appreciate, again, your all being here. I now turn to the ranking member for his opening statements. Mr. Schmucker. I want to recognize the distinguished ranking member for the purpose of making an opening statement.
Thank you, Madam Chair. Thank you for yielding. Each year, Americans take on more and more student debt, so it's no surprise that borrowers have demanded help. College costs continue to surge, so Congress has stepped in. But too often, overreaching government intervention may not lead to positive reforms. And you can just look at the Public Service Loan Forgiveness Program, which is indeed a broken promise intended to help borrowers working in public service professions struggling with their student loan debt. Congress then doubled down on that same broken promise when $700 million was pumped into a new program called the Temporary Expanded Public Service Loan Forgiveness, or TEPSLF. The purpose of today's hearing should be to come up with solutions to solve program confusion for borrowers, because our constituents are working towards loan forgiveness, or the constituents who are working towards loan forgiveness are the ones who we should be here to serve. But whether you support or oppose the programs is irrelevant for the purposes of today's conversation. And I have sincere hopes that today's hearings will really be an attempt to resolve these issues and not be used to grandstand or to point fingers. My colleagues, based on some of the information we've seen in advance, will repeatedly point to one GAO statistic, that 99% of TEPSLF applicants were rejected since the program began in 2018. Well, that's certainly not the outcome that we'd hoped for, and certainly makes for a great headline. But sadly, it stretches the truth and only tells a fraction of the story. So I'll highlight some of the important facts and figures that my colleagues will conveniently leave out. 71% of TEPSLF applicants were denied because they did not submit a PSLF application. According to the law, TEPSLF is only available to applicants who are ineligible for PSLF. Of the 29% of applicants who cleared the first hurdle by submitting a PSLF application, roughly only 4% were ultimately eligible for TEPSLF. This number illustrates just how tightly Congress defined that eligibility. Also, the GAO report determined that the Department of Education followed the law precisely. And nowhere in the GAO report did they find the Department of Education was improperly denying borrowers forgiveness or slow-walking the implementation process. So we can't blame the Department of Education. We can't blame FIA for high loan forgiveness rejection rates when it was narrowly designed legislation, and in fact combined then with years of the Department of Ed under the Obama administration, years of inaction that brings us to today's problem. So again, FIA, Department of Education, there is not a scapegoat that we should be trying to pin the issues on. The Department of Education is following what is a very complex law, in fact, as written by Democrats. It's just not the law that Democrats wish they had passed in 2007. Spinning data to drive a political agenda doesn't serve the American people. Might make for some great headlines and Twitter material, but it certainly does nothing to help frustrated and struggling American borrowers. Talk is cheap, but failing policies, such as in a case like this, are costly. Thank you. I yield back.
Thank you, Mr. Smucker. And with that objection, all other members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. on October 3rd. I'm now delighted to introduce our witnesses for the first panel. First is Kelly Finlaw. Ms. Finlaw started her 14th year of teaching middle school art in New York City. She teaches at the B. Fullard Rogers School, IS 528, which is a public middle school located in Washington Heights. She has taught middle school in Washington Heights since she started teaching and has lived in the same neighborhood as her school for the past 11 years. As a public school teacher in NYC, she is an active member in the United Federation of Teachers and the delegate for her school's chapter. Next, we have Yael Shavit. Yael Shavit is an Assistant Attorney General in the Consumer Protection Division of the Massachusetts Attorney General's Office. Her work addresses a wide range of consumer protection issues with a focus on student loans and higher education matters. Before joining the Massachusetts Attorney General's Office, Yael held a Ford Foundation Public Interest Fellowship at the National Consumer Law Center and served as a San Francisco Affirmative Litigation Project Fellow and lecturer in Yale at Yale Law School. Lecturer in law, at Yale Law School. Finally, Matthew Shingos directs the Center on Education Data and Policy at the Urban Institute. He leads a team of scholars who undertake policy-relevant research on issues from pre-kindergarten through post-secondary education and creates tools such as the Urban's Education Data Portal. Shingos is co-author of Game of Loans, The Rhetoric and Reality of Student Debt and Crossing the Finish Line, Completing College at America's Public Universities. He has testified before Congress, and his work has been featured in media outlets such as the New York Times, the Washington Post, and NPR. Before joining Urban, Shingos was a senior fellow at the Brookings Institution. He received a BA in government and economics and a PhD in government from Harvard University. Pursuant to Rule 7D, the witnesses will please stand and raise their right hands. Thank you. Do you solemnly swear or affirm that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record show that the witnesses all answered in the affirmative. We appreciate all of the witnesses for being here today, and we look forward to your testimony. I want to remind the witnesses that we have read your written statements and they will appear in full in the hearing record. Pursuant to Committee Rule 7D and committee practice, each of you is asked to limit your oral presentation to a 5-minute summary of your written statement. Before you begin your testimony, probably see the button in front of you. If you'll remember to press it on the microphone so it will turn on and the members can hear you. As you begin to speak, the light in front of you will turn green, and after 4 minutes, the light the light will turn yellow to signal that you have 1 minute remaining. When the light turns red, your 5 minutes have expired, and we ask that you please wrap up. We will let the entire panel make their presentations before we move to member questions. When answering a question, please remember to once again turn your microphone on. I will first recognize then Ms. Finlaw.
Good morning, Chairwoman Davis, and members of the committee. My name is Kelly Finlaw. I am a middle school art teacher at IS 528 in New York City. I am a proud member of the United Federation of Teachers and the American Federation of Teachers. On behalf of the 1.7 million members of the AFT, I thank you for inviting me here today to share my experience with the Public Service Loan Forgiveness Program. Apart from being with my family, with people that I love, my classroom is my favorite place on earth. Being a teacher is one of the most difficult professions in the world, but I clawed tooth and nail to make it, and I am doing what I was meant to do. There are moments every day that overwhelm me, that stop me in my tracks. There are moments of gratitude that this is how I get to spend my life. Going to college was my only option after high school. My mother made sure of that. But even though she worked several jobs to make ends meet, there wasn't anything left over to pay for my education. So student loans kept me in my classes every semester. I didn't go into education so that the government would pay my loans for me. The PSLF program didn't even exist when I started teaching during the 2006-2007 school year. I took on the debt that I have because it was a means to an end. I expected to carry this debt with me for the rest of my life, a small price to pay for a life that already feels like I've won the lottery every day when I walk into my school. In 2007, after I'd already started teaching, a bipartisan law was set into motion that I believed would alter the course of my financial future. A promise was made to me, to my colleagues, and to all public workers that should we continue to serve our communities for at least 10 years and make 120 qualifying payments on our student loans, our debt would be forgiven. Teaching isn't a career that garners much respect from anyone outside of the profession, but this promise was validation that the work that we do every day is valuable. The promise that Congress made to me and to all public sector workers gave me hope for my future. When I learned about the law, I called my loan servicer and said, "I'm a teacher, what do I need to do to qualify for the PSLF program?" I made these calls repeatedly to different loan servicers over the span of several years. The answer was always the same: just keep making payments and after 120 you will qualify. After 10 years of making student loan payments, October 2017 was my month, my light at the end of the tunnel. I received an email from my servicer, Nelnet, letting me know that I was eligible to apply for PSLF. I filled out my paperwork immediately. Once I applied, my account was transferred to FedLoan, the exclusive servicer for PSLF. I received a letter from FedLoan a few weeks later, a letter I had dreamed of for 10 years. I remember standing in my living room when the light at the end of the tunnel went dark. The Department of Education denied my application for public service loan forgiveness. The reason, which no loan servicer had ever raised, was that one of the loans was not a direct loan. I called FedLoan immediately. I was told to reconsolidate so that all of my loans would qualify. Once I reconsolidated, I was transferred to Nelnet, and I called and asked, "All of my loans qualify. What do I need to do now?" I was told that my qualifying payments had been reset to 0, and I would have to keep paying for 10 more years. I have now made 5 payments toward my second round of 120 payments. According to Nelnet, I am 115 payments away from forgiveness, while simultaneously being 5 payments past. I dream of owning an apartment in my neighborhood, but how can I afford a mortgage when I recently had to decrease what I contribute to my pension in order to cover my monthly bills? I do not share my story with you today to seek sympathy. I wouldn't trade my life with any other person on this planet. I share my story because there was a promise that was made to me and to millions of other public servants, and that promise is being broken every day. As of March 2019, the Education Department had forgiven the debt of 518 public servants, less than 1% of its applicants. I vacillated between anger and despondence when I was denied forgiveness. I tried to find answers on my own, but it wasn't until my union reached out that I felt like I had a voice again. I never thought I would say this, but I'm a plaintiff in a lawsuit against Betsy DeVos and the Department of Education. The Weingarten v. DeVos lawsuit is seeking a court order that will hold the Education Department accountable for the errors and misrepresentations of its loan servicers and allow borrowers who have been denied due process. Congress has already made an effort to rectify the issues in this program, allocating $700 million for the temporary education PSLF program. Yet no one proactively talked to me about applying for TEPSLF. I had to research on my own. I do not understand why Secretary DeVos would not do everything in her power to help teachers like me, who did everything right, receive the loan forgiveness we were promised. I urge her to take action, which is within her authority, to fix this broken system. As I stated before, I do not come from a wealthy family. I took out student loans because it was the only way that I could earn a degree, and to date, I am the only member in my family to have that honor. If the PSLF program wasn't meant for me, a teacher who loves her job, pays her bills, and comes from a family where loans were her only option, who was it meant for? I'm extremely grateful to have this opportunity to speak before you today, but the truth is, I would prefer to be in my classroom right now. Today will likely be the only day I am not in my classroom for the rest of the year. I am here today because I have no other option, no other hope for my own future. I am here today so that you can see the face of a person who has been impacted by the gross mismanagement of PSLF. Thank you for your time.
Thank you, Ms. Finlaw. Ms. Shavit, please proceed.
Chair Davis, Ranking Member Smucker, and members of the subcommittee, thank you for inviting me to testify today. My name is Yael Shavit, and I am an Assistant Attorney General in the Massachusetts Attorney General's office. On behalf of Attorney General Maura Healey, I appreciate the opportunity to share our serious concerns about the implementation of the PSLF program. Advocating on behalf of students is a central priority of our office. Our office has brought some of the first enforcement actions against student loan servicers and works directly with borrowers to help resolve issues that arise with their loans. Through this work, we regularly see firsthand both the importance of the PSLF program and the profound financial injuries suffered by public servants due to the mismanagement of the program. As you know, Congress created the PSLF program to allow public servants to manage their student loan debt by providing them with loan forgiveness after 10 years of service. Without this program, people interested in dedicating themselves to public service careers often would be unable to do so because of the steep costs of higher education. The PSLF program is critical not only to the borrowers who rely on it, but to the broader societal interest of ensuring that skilled workers can serve in public sector jobs. Nonetheless, we have seen time and again how diligent, hardworking public servants who had every reason to believe that they were meeting the program's requirements are being denied the benefit of PSLF after years of work. Our office's investigations have revealed widespread mismanagement of the PSLF program by both student loan servicers and the Department of Education. In 2017, we brought an enforcement action against FIA, also known as Fed Loan Servicing, which has the exclusive contract to manage the PSLF program. Our lawsuit alleges that FIA, by engaging in widespread loan servicing failures, has caused financial harm to thousands of Massachusetts residents seeking to rely on PSLF. Despite being aware of these problems, the department has failed to adequately oversee its servicers, and it has failed in its own administration of PSLF. Borrowers have been misinformed about the requirements of PSLF and have been told incorrectly that their loans or employment qualified for the program when they didn't. Borrowers have had their payments miscounted and their applications delayed. They've been excluded from qualifying repayment plans through no fault of their own. In short, the system is deeply broken. The problems with the administration of PSLF came into sharp relief in 2017 after the first participants in the program became eligible for loan forgiveness. Only 96 people out of over 28,000 initial applicants had their loans forgiven. This extraordinary denial rate should have served as a wake-up call to the department that it needed to overhaul its oversight and management of PSLF. Unfortunately, the department has failed to demonstrate a commitment to the program or to public servants. We have seen this lack of commitment firsthand. Rather than working with our office when we identified FIA servicing failures, The department instead empowered FIA in its failed efforts to evade our enforcement authority by invoking inapplicable federal preemption principles and privacy statutes. It is now clear that the department is also impeding Congress's efforts to help public servants. Despite Congress's appropriation of $700 million to temporarily extend PSLF, the department has once again denied approximately 99% of applications for relief. The department's continued failure to administer the PSLF program appropriately is disheartening and unacceptable. We appreciate the subcommittee's focus on this issue. The PSLF program is important, and we believe that it is essential that the program's administration be fixed, not only for those public servants who have already relied on the program, but also for future borrowers who are willing to commit themselves to the public good and the countless Americans who benefit from their service. On behalf of the Massachusetts Attorney General's Office and the borrowers we represent, we urge Congress to continue to use its oversight authority and demand accountability from the department and its servicers. Students across the country are counting on it. Thank you.
Thank you, Mr. Veet. Dr. Shingles?
Chair Davis, Ranking Member Smucker, and members of the committee, thank you for the opportunity to testify today about the Public Service Loan Forgiveness Program. I direct the Center on Education Data and Policy at the Urban Institute here in Washington, D.C. I'm proud of the work we do at Urban, but I should emphasize that the views expressed in this testimony are my own and should not be attributed to any organization with which I am affiliated, its trustees, or its funders. My testimony will provide an overview of PSLF and the temporary expanded PSLF program, with a focus on program design, trade-offs, and options for reform. I am not an expert on student loan servicing, but I believe that the complex design of loan forgiveness programs plays an important role in the challenges faced both by borrowers trying to navigate these programs and by the federal government administering them. PSLF sounds like a simple program. Work in public service for 10 years and have your loans forgiven. But the program is complicated and has only become more complex over time. First, Congress limited the program to borrowers who took out loans under the direct loan program, and it may not be obvious to borrowers which kind of loan they have. Second, borrowers need to prove they worked in public service, which the federal government defines based on the legal status of the employer, not the job being done. For example, nurses at nonprofit hospitals are eligible, but nurses doing the exact same work at for-profit hospitals are not eligible. Third, borrowers need to spend at least some time in an income-driven repayment plan. Payments made under the wrong plans do not count toward PSLF. Such a complex program has led to borrower confusion. A 2018 GAO report on PSLF found that, of the borrowers who applied for forgiveness, only half had any qualifying employment and loans, and less than 1% had made 120 qualifying payments. Congress attempted to address borrower concerns about PSLF by creating TEPSLF, a first-come, first-served pot of money for borrowers who met all the requirements of PSLF, except they were in the wrong repayment plans. As with PSLF, few TEPSLF applicants have been approved for forgiveness. But the denial rates alone don't tell us whether these programs have reached their intended beneficiaries. To judge success, we need to know how many borrowers are actually eligible under the terms of the programs, how many are applying, and how many are being approved. It is impossible to precisely estimate how many borrowers are eligible for these programs because the federal government does not collect comprehensive data on borrowers' sector of employment. This has left the press and Congress to focus on the fact that 99% of applications were rejected and not on why they were rejected. The recent GAO report does not tell us much about the share of eligible borrowers who are able to access the program, but provides insight into why so many borrowers were rejected. 71% of TEPSLF applications were denied because the borrower had not yet submitted an application for PSLF. Of the applications that did meet the requirements of first applying for PSLF, 96% did not meet the other eligibility requirements, including making 10 years of qualifying payments on eligible loans and meeting payment size criteria set by Congress. The hard truth is that a program as complex as TEPSLF is likely to continue to be confusing, as evidenced by borrower confusion about the PSLF program, which has been in place for much longer. In addition to creating confusion, PSLF distributes the largest benefits not to the neediest borrowers or those who contribute most to the public good, but to borrowers with the largest debts who know how to navigate the system by obtaining the right kind of loan, picking the right repayment plan, working for the right employer, and even filing their taxes the right way. Programs like PSLF could be more effectively administered if the onus was on the government rather than borrowers to measure eligibility. For example, Congress could consider modifying the program to simplify eligibility rules and provide forgiveness using administrative data, such as from the IRS, rather than using a cumbersome application process. A more ambitious option is to shift the resources currently dedicated to PSLF to alternative policies aimed at the same goal. Research shows that targeted scholarship programs are more effective than loan forgiveness. In my view, efforts to reward socially valuable employment, such as social work and teaching, would be better accomplished through grants or through carefully tailored wage subsidies. In conclusion, many of the challenges of implementing PSLF and TEPSLF stem from the complex design of these programs. Discussions about how to improve the administration of loan forgiveness programs should be accompanied by careful consideration of how these programs might be reformed to reduce confusion and make them work better for both borrowers and taxpayers. Thank you for the opportunity to testify today. I look forward to answering any questions.
Thank you very much. Thank you to all of you staying within time limits, and we look forward to the questioning. Under Committee Rule 8A, we will now question witnesses under the 5-minute rule. As chair, I've decided to go at the end, so I will yield to the next senior member on the majority side, and then we will shift over to the ranking member and go back and forth. Again, I want to now yield to Mr. Courtney of Connecticut for the first questions.
Thank you, Madam Chairwoman, and to Mr. Smucker for holding this hearing today. To all the witnesses, particularly Ms. Finlaw, for really telling the human side of this. Again, I think most members, I would assume, certainly my office, has gotten these calls. And I mean, the crushing disappointment that people experience when they built their whole life plan and professional career for 10 years, to get that rug pulled out from under them is just devastating. Before I begin my questioning, I want to join the chair to express my frustration with the CEO of FIA, known to consumers as Fed Loan Servicing, for refusing to testify today. Fed Loan is the sole loan servicer implementing PSLF. If a borrower hopes to obtain PSLF, they have to speak to Fed Loan. So I think, as Ms. Finlaw maybe knows from some of her colleagues, there are other loan servicers that deal with Title IV, Stafford loans, Perkins loans, all of them. But if you want to apply for discharge under PSLF, the loan has to be given to this one sole gatekeeper, Fed Loans. And that's why their refusal today to be accountable in a public forum when the program they administer fails more than 99% of the borrowers that, again, have to go through that bottleneck, is really outrageous. According to USA Spending, Fed Loan has collected over $1.3 billion in taxpayer dollars because of the servicing contracts that they have with the Department of Education, and yet they refuse to appear today to publicly discuss how they actually spent the taxpayers' money. Fed Loan is currently competing today also for the department's next-gen loan servicing platform. This is a multi-billion-dollar contract that the department claims will address many of the problems leading to PSLF's failure, and yet Fed Loan's chief executive officer refuses to engage with Congress about the problems implementing the last billion-dollar contract that it received. And I want to just note for the record, again, the refusal to testify here today occurred on September 13th, and that was before the witness list was released. And I just, again, want to leave that on the record. So, today, since they're not here, Ms. Shavit, who's suing Fed Loan Servicing in the state of Massachusetts, and since they're unwilling to share their side of the story, I'd be interested in hearing what you have to say about their practices. Can you explain how Fed Loan's practices have prevented borrowers from qualifying for PSLF, and are there other ways that Fed Loan practices cost borrowers money?
Sorry, certainly. Fed Loan Servicing failures affect a number of facets of PSLF. So as we allege in our complaint, Fed Loan failed to timely process borrowers' applications to participate in qualifying repayment plans. As a result of the backlogs and the delays that this caused, FIA decided to place some borrowers in forbearance status, which is itself not a qualifying repayment status. The effect of these servicing failures was to deprive borrowers of the opportunity to make payments that would qualify for PSLF. In effect, what this does is prolong borrowers' repayment obligations inappropriately and increase the likelihood that they will never qualify for PSLF. Additionally, FIA failed to correctly count and track borrowers' qualifying payments, causing borrowers to be credited with fewer qualifying payments than they actually made. Again, this throws borrowers off track. I think it's also important to note that the problems that affect PSLF borrowers aren't just servicing failures that are specific to FIA's management of PSLF. Servicing failures across FIA's platform, across their work, have ripple effects that throw PSLF borrowers off track. So additional servicing failures that have been reported, including the misapplication of payments, can also have the same effect of throwing borrowers off track. Additionally, we are aware of borrowers, as Ms. Finlaw has described, who have been misinformed by FIA about the qualification of their employment or their loans for PSLF. And relying on this information, borrowers have spent years, sometimes up to a decade, thinking that they were on track to get PSLF forgiveness, only to discover the error when so much time had passed that they were unable to make the critical changes in their lives to actually become eligible for PSLF. I'd also like to note a different failure, which I think is important to recognize, and that's the failure that happens when FIA recognized its servicing errors and didn't immediately take measures to both identify the entire population harmed by its servicing errors and to then make sure that those borrowers were made whole. It should be FIA's priority to make sure that those borrowers are made whole, and frankly, it should be the department's priority to make sure that FIA does so.
Thank you. Again, just also want to add quickly for the record, the administration has submitted 2 budgets since taking office in 2017 for fiscal year 19 and 20, and both at times they have zeroed out the PSLF program, which again, I think kind of screams out about what their support and priority for this program is, and I yield back the balance of my time.
Thank you. I would now turn to the ranking member, but he's decided to go further down the line, and I now call on Ms. Stefanik of New York.
Thank you, Chairwoman Davis and Ranking Member Smucker. I believe that all of my colleagues understand the frustration and confusion this program has caused for borrowers. And while Congress created the Public Service Loan Forgiveness Act in 2007 with a noble intent, I believe that we must fundamentally reform and improve this program so that we're understanding its shortcomings and it actually reaches what the intent is, that's easier for the student and incentivizes public service. So my first theme I wanted to cover today is what qualifies as public service and what should. Dr. Chingos, you talked in your testimony about how the government defines public service based on the legal status of the employer, not the actual job being done. Can you elaborate on this and explain how it may cause confusion for employees?
That's exactly right. It's about the legal status of the employer. So if your employer is a government employer or a 501c3, and there's another category we don't have to talk about, you're eligible. And if you're not, so for some borrowers, that's pretty obvious, right? If you're a teacher, you're going to probably be a teacher for the government or for a private school, which is probably going to be a nonprofit private school. You're clearly eligible, at least on that component. But if you're a nurse, some nurses are at for-profit hospitals, some are at nonprofit hospitals. So there's a number of kinds of occupations that's very much the same kind of work. So if you're a journalist at NPR, you're eligible. If you're an investigative journalist doing the great work the Washington Post does, you're not eligible. So that is maybe sometimes could be lost on borrowers and could lead to some of the confusion we've seen.
So, GAO has noted that about 25% of the workforce in this country is encompassed in this broad definition of public service. It seems that defining public service more precisely would be necessary to focus the program's intent and eliminate confusion for borrowers. What are some of the factors that we should consider when trying to address this nebulous definition that exists today?
I think it's really about trade-offs. So as you mentioned, a quarter of the economy currently falls into the current definitions. That's going to be a pretty wide net you're casting. So if Congress wanted to be more targeted, you could think about trying to encourage certain kinds of more targeted public service. So let's say we decide there's a shortage of nurses and doctors in rural areas. We could create a program for that population. And indeed, there is several examples of programs like this. So there is a program for nurses in high-need areas. There is a program that's just for teachers that's separate from the PSLF program. And actually, if you sign up for that, you can lose your payments towards PSLF. That's a whole other tangled web of competing, conflicting programs confusing borrowers. But the point is we have examples of more targeted programs, and there's just a real trade-off between trying to capture as many people as possible and trying to do this in a way that's more targeted to clear goals.
I think creating more flexibility in what the needs of the particular communities are. So I represent a very rural district. We need healthcare experts. We need healthcare providers. We need nurses. We need farmers in our district. Those needs are very different than other parts, perhaps more urban regions across the country. The second theme I wanted to focus on today are specific ideas about how we can reform the program. You know, one of my concerns is that the lump sum payment of forgiveness on any unpaid debt, if we shifted that to more of an annual payment towards a borrower's balance, are we then able to reduce the incentive to overborrow and provide a more even distribution to the benefits of the program?
I think there would be some advantages of moving to more staged forgiveness. It would simplify things, certainly, so that it's not you wait 10 years and then found out that you either were confused or you had gotten bad information. So it could be helpful in that way. There's certainly a trade-off there in that it would alter the distribution, so it wouldn't just be for people who made reasonably low incomes over a longer period of time. A doctor who was in residency for 4 years could get it, even though they're making a lot of money later. So there's a trade-off there, but it could certainly be part of an effort to simplify the program.
What do you think about the proposal to cap the amount any one borrower may receive?
That could help focus the benefits on a sort of broader set of people and really on people who borrowed for college. The way that you get the most benefits now is by borrowing a lot of money. So if you come out with a typical debt of $30,000 and start with a salary of, say, $45,000, you're not going to get any loan forgiveness. So really, in order to be eligible for, say, the six-figure amounts of forgiveness or just the average PSLF forgiveness we've already seen of about $59,000, you have to borrow for graduate school. So the current program is very tilted towards people with lots of debt, people with graduate degrees, and in some cases, people who have made not very high incomes, but reasonably high incomes. So putting a cap on it would focus it more on folks who just borrowed for undergrad.
Thank you very much, and I yield back the 7 seconds.
Thank you. Now turn to Mr. Takano of California.
Thank you, Chairwoman Davis, for this very important hearing on the Department of Education's mismanagement of the Public Service Loan Forgiveness Program. This program was created as a way for Congress to say thank you to the many dedicated public servants in this country that sacrificed high-paying jobs and who instead work in their communities. Unfortunately, Congressional Republicans and the administration do not like this program. It is evident from every attempt that the President has made to eliminate the program and every budget he has put forth since being in office, as well as the ranking member's proposal to eliminate the program in the PROSPER Act. Unfortunately, it is this administration that is tasked with implementing this program. And from where I sit, it is evident that they are purposely sabotaging this program. It's shameful. Ms. Shabbat, my first question is for you. It appears that FIA has engaged in deceptive practices. What type of oversight do you believe the Department of Education should have over FIA and other loan servicers?
I believe it's critical that the Department of Education play a rigorous oversight role. It's important to remember the Department of Education selected these servicers to manage these student loans on its behalf. And in the context of PSLF, the department has entrusted the entire PSLF program to one servicer. So the department needs to play an active oversight role. And part of that active oversight role in the context of the failures of PSLF should have involved the department stepping in when it saw that FIA was mismanaging the program. And the department should have required the following things from FIA. It should have required FIA to get at the root causes of the servicing failures that were harming borrowers. It should have required FIA to identify the entire universe of borrowers who had been harmed. And then it should have required FIA to take steps both to make those borrowers whole and to make sure that the problems were fixed so they wouldn't affect future generations of borrowers.
Wow. It's inconceivable. It's just one contractor, one company that's the loan servicer for these loans. And what recourse does the Department of Education, what should it do if loan servicers are just not complying with the terms of their contracts?
The department has significant powers to create consequences for the mismanagement. Actually, Earlier this year, the department's own Office of Inspector General came out with a report that included the conclusion that the department was failing to create incentives for servicers to comply with servicing requirements by failing to create consequences and accountability when servicers weren't compliant. We see this playing out in the context of PSLF. There should be consequences to FIA for its continued failure to manage this program correctly. The department is authorized and, to the best of my knowledge, has not undertaken to exercise its authority to penalize FIA both financially and, quite frankly, the department should consider in the context of future bids for these contracts whether FIA is up for the task of continuing to manage this program.
Thank you very much for your testimony. I want to move on to Ms. Finlaw. Ms. Finlaw, the Department of Education has a responsibility to people like you to ensure that we keep our initial promise and provide the loan forgiveness that Congress intended. So, Ms. Finlaw, as you have noted, you have had several loan servicers over your 10-year period of your loan. Did any of those loan servicers ever send you information about PSLF?
I was notified in the fall of 2017 that I was eligible to apply for this program.
And can you give us a sense of, how long had you had the loans taken out at that point?
I started taking loans out in 2001.
2001.
But I started teaching in the 2006-2007 school year, so I was eligible at the 10-year mark because it went into law in 2007. So at the 2017, at that year, I was sent an email. Was I notified throughout those 10 years? No. I had to fill out an application every year to be on an income-based repayment plan, which meant that I had to submit my taxes and proof of employment every year. And those conversations centered around, this makes me eligible for PSLF, I'm on track. And the answer was always yes.
Okay, so this next question you may not know the answer to, but you had different loan servicers. Did you ever encounter these other loan servicers that were unaware of the loan forgiveness program?
No one ever said that they were not aware. It was always a conversation.
Okay. Did they ever proactively reach out to you to let you know what your status was?
No.
No. Or did you have a call to inquire? Did you have to call to inquire that you were still on track?
I called every year when I had submitted my tax forms and my employment because you have to be on an income-based repayment plan. So those conversations happened yearly with a variety of different loan servicers depending on where my loan was at.
And you were never informed about your eligibility?
No.
Okay, thank you.
Thank you. Mr. Grothman.
Before I start, I'd like to briefly yield to Congressman Smucker.
Thank you. I just wanted to take the opportunity to just share a little bit about FIA, which is a Pennsylvania state agency, the state I come from, who has as its core a public service mission to create affordable access to higher education. FIA is responsible to a bipartisan board of directors and responsible to the Commonwealth of Pennsylvania. In fact, as chair of the Education Committee in the State Senate, I served on FIA's board, saw firsthand the work that they did in promoting access to higher education. Just one statistic. Since the financial crisis, FIA has used $1 billion of its resources in benefiting students to supplement need-based programs which provide direct cash assistance to students. Really, there's very few, if any, organizations in the student loan servicing space that have given so much benefit to so many. I know personally that FIA would like to be a constructive partner in helping to improve this system and helping to improve the law. But as a servicer of the Department of Education, they must follow the rules and requirements of what is a congressional program, rules put in place by Congress and administered by the Ed Department. And additionally, FIA, as you all are aware by now, is engaged in active litigation with one of the witnesses who is here today. And the majority staff was aware of that fact when they chose to invite the panel of witnesses that they selected, yet, and I think shamefully, decided to make a spectacle as opposed to conducting good oversight. With that, I yield back.
Thank you. I was not in Congress at the time this program was originally instituted. Apparently, and I'll take the chairman at her say-so, I think apparently the design of the program was to discourage people from going into the private sector as someone who represents a lot of manufacturers strong in the agriculture community. I hope when we get done introducing legislation in the committee, and I suppose the goal is to introduce legislation, we should not treat people who go into the very difficult sectors like manufacturing and agriculture as second-class citizens. I think a lot of times it's very difficult to go into those fields as the economy goes up and down. Frequently people in manufacturing lose their job. Rarely do people in public sector lose their job. And I hope when we reintroduce legislation here, we do not continue down the path of discouraging people to going into the jobs that are so vital to keep our economy moving. Whenever I tour my factories or agriculture facilities, I feel so grateful to the people who go into those areas, and I hope that the new bill we introduce doesn't treat them like second-class citizens. Okay, now, Dr. Chingos, to your knowledge, how much action did the Department of Education take regarding PSLF in the first few years of the Obama administration?
So the exact implementation of this law is a little bit outside my area of expertise, but my understanding is that it was a few years from when it was passed in 2007 until I think it was 2012 is my understanding when action was first taken. Okay, so for several years, and I don't mean to pick on them, it's very difficult to run this federal government. It's far too big, but for many years after the law was passed, the Obama administration really didn't get up and running and kind of left a little bit of a mess for Secretary DeVos to deal with. Do you think that's accurate? Once again, I'm not a scholar of the kind of history of this program, but obviously it's been in place for a long time, and the data we have from GAO report back in 2015 and the current GAO report indicate that some of the questions, challenges are certainly not something new. Sure. One more time a lesson. If you want something done, don't ask the federal government to do it. But, okay, now, we're here that 99% of the borrowers have been denied. Do you feel denied is the right word for these borrowers, or were they just not eligible? So the data we have from GAO indicate that at least there's the 71% who hadn't first applied for PSLF. So we don't know whether they would have been eligible. They would have had to apply again, and some of them indeed may have. But for the other 29% who met that first requirement, the data we have indicate that 96% of them were not eligible. We're not eligible. So it was a poorly designed program by Congress. We shouldn't put the blame on the Department of Education today because Congress did a bad job or overpromised in 2007 when the law was passed. You think that's accurate? I think it's pretty clear from the design of the law that a lot of the challenges, maybe not all the challenges, but certainly a lot of the challenges come from the complex design of the program. Okay. Thank you.
Thank you. Thank you, Mr. Grothman. Your time is up. Jayapal.
Thank you, Madam Chair, and I'd like
From
to
Washington State.
Thank you. I'd like to yield to you briefly for your comments.
Thank you, Mr. Jayapal. I just wanted to clarify because it is my understanding, and I believe that the staff is well aware that, as Mr. Smucker stated, we actually had quite a number of signals that FIA had chosen not to show up today, and that was well before Ms. Shavit was invited to be here, so had no relationship to that. I think, as we can tell from the testimony, it would be very helpful to have them here, and I think that they were in error to not be here because again they're the sole company that is engaged in this effort. And it's important to hear from them. They may have had suggestions that would be very helpful to us to hear.
Thank you, Madam Chair. Thank you, and thank you all very much for being here. And I wanted to just start out by laying out the situation as I see it. 12 years ago, Congress passed a law that would encourage people to take relatively lesser paying jobs in public service. That's not diminishing any other profession. It's saying that public service is an important public good, and we want to encourage people to go into public service, but there was a contract in exchange for that, full forgiveness of their student loans after 10 years of repayment. Thousands of Americans then enrolled in this program. And they worked full-time for 10 years in public service. They dutifully made their payments on their student loans, only to find out at the end of the 10 years that they had a 1% chance of achieving the promise of freedom from student debt. And I think, Ms. Finlaw, your story perfectly demonstrates the problem with this. It was a promise, it was a contract, people followed the rules, and then at the end of the game, they were told that they didn't qualify. I want to thank you for taking time away from your students to be with us today, Ms. Finlaw. I know how much you love that job, and you said that in your testimony. Ms. Shavit, you're an Assistant Attorney General in the Consumer Protection Division of the Massachusetts Attorney General's Office, which brought some of the first enforcement actions against student loan servicers. And your office also works directly with borrowers to help resolve issues that they encounter with their loans. You've heard about the timeline of the invitation to FIA's CEO, and I just would like to get your opinion about why their CEO has rejected Congress's invitation to testify today. Were you surprised by that, and if so, why?
I wish I could say that I was surprised by that, but frankly, it's consistent with the approach that I believe FIA took during our investigation. While I might not be surprised, I am disappointed. I think it's critical that we get to the bottom of what's gone wrong with the implementation of PSLF. I think that FIA has unique insights into this, and I would have hoped that they would prioritize the interests of borrowers and the interests of this program and come and share those insights today, and it's discouraging that they chose not to.
It sounds like you're saying that perhaps they're scared, and rightfully so, of being exposed for wrongdoing. You're sitting next to one of the many individuals rejected for the PSLF after making on-time payments for 10 years. I wanted to lift up the story of one of my constituents who earned a master's in education to teach at a local community college. She told me she was instructed by her servicer to consolidate her loans into direct loans, and she'd be all set. Several years later, she received a letter telling her that none of her payments counted because she was in the wrong repayment plan. And after calling her servicer again and again, she was told that they didn't know who she talked to before, but she must have been given the wrong information. This is a very common story. Can you tell me specifically what are, the top 1 or 2 practices by FedLoan that are hurting borrowers, Ms. Shavit?
I think it's hard to rank them because, quite frankly, there are so many servicing failures that are compounding to make really serious problems and obstacles for borrowers to be able to avail themselves of this program. Certainly, the misinformation that you've identified just now is a crucial mistake. It's a very big problem for borrowers, and it stops them from ever getting the benefit of the program. But in addition to that, a series of other more general servicing failures, including the failure to process people's applications timely, compound to create a scenario where borrowers lose multiple opportunities to make qualifying payments, dragging out their repayment obligations and decreasing the likelihood that they'll ever be able to benefit from the program. And of course, FIA's failure to accurately count borrowers' qualifying payments deprives people of actual credit that they should be entitled to.
Thank you, Ms. Shavit. What's clear to me is that FedLoan has raked in $1.3 billion over the past 10 years and has little to show for it, overcharging borrowers, failing to process repayment applications, unacceptably long wait times. These findings point to an overburdened company that can't meet the terms of the contract to serve the American people, and our public servants are suffering as a result. Thank you, Madam Chair.
Thank you very much. Mr. Muser of Philadelphia, Pennsylvania.
Thank you, Madam Chair. Thank you all. I'm trying to get a better understanding of how this all originated, how it happened. How did borrowers become, Dr. Chingles, let me ask you this, please. How would borrowers originally become aware of this program?
So they could become aware from reading about it. I think in some cases they could learn about it from their servicer, but as I said, the servicing piece of this is, my expertise is more on the program design than on the servicing.
Let me ask you this then. How would a nurse in the private sector believe that they were eligible versus a nurse in working for a nonprofit? Why would they think that they were falsely eligible?
Well, they might think they were eligible if they feel nursing is serving the public good, which I think it's reasonable. A lot of folks probably think that. I certainly do. And perhaps they have some friends at another hospital who found out that they're eligible for this program.
Did any of them receive a letter stating, congratulations, you're eligible for this program? Is any of those who were considered non-eligible receive documentation that they were actually eligible? Was that mistake ever made?
So the federal government doesn't collect data on sector of employment. So to sort of prove your eligibility for this program, it's the borrower that has to go to the federal government. So you, in theory, could get a letter from the government or from your servicer saying, hey, you should know about this program and look into whether you're eligible, but the government would have no way in a comprehensive way of going to their borrowers and saying, hey, you might be eligible.
So there's no one claiming eligibility of all these thousands, perhaps a million, that actually received a document stating that they were eligible, as far as you know?
Well, borrowers can certify their employment and their loans with their servicer before the 10 years have passed. So so one of the problems with this complex program is it's a retroactive program. So if you wait to the end of 10 years to do all the paperwork, you're probably going to, potentially have some issues. Go to some employer from 8 years ago, get them to fill out a form. So there now is a system in place where you can certify your employment and loans each year and have the government tell you, yes, you're on track.
Okay. Are you reviewing eligibility, to the best of your knowledge, is FIA reviewing eligibility requirements now of those who are requesting the reimbursement?
I mean, my understanding is that's a process that's ongoing now, but once again, not an expert on the details of it.
Okay. Madam Chair, I yield the remainder of my time to Dr. Fox.
Thank you, Mr. Muser. There's several things that I would like to put in the record right now about what's happening in this hearing. Number one, and we're going to say this over and over, the Secretary must follow the letter of the law. That is her constitutional duty. Accusations that she can do anything else are false. I want to enter into the record, Madam Chairman, a chart that has been prepared by the staff which outlines the Education Department's implementation of PSLF. And it shows from its beginning, 2007, when PSLF was established, and then it shows that under the Bush administration, a couple of rules were issued. The first one was defining public service organizations and full-time. From January 2009 to January 2012, not one word out of the Obama Education Department on PSLF. No guidance whatsoever to anyone. Then in 2012, an employment certification form. Then 2013, nothing in 2014 whatsoever, 2015. Then 2016, an email campaign targeting 3.3 million borrowers. So it is, I think, mismanagement in the Department of Education long before this administration came along that has created this problem. I'd also like to enter into the record something from the Department of Education's website, which I have read, and it's 7 steps for PSLF success. I believe that anybody with a college degree should be able to read this and understand it and follow it. It is about as clear as it can be as to what the requirements of the law are. And then I'd also like to submit for the record the statutory language for PSLF so that all of our colleagues can read it. It's pretty clear, complicated, but clear. I'd like to enter into the record Public Service Loan Forgiveness Program, Statute 685.219, and the TEPSLF statutory language. It is really important that we understand the basis of these programs. Thank you, Madam Chairman. I yield back.
Thank you. Let's see, we're now turning. Oh, without objection, we'll certainly take those for the record. Sorry, if we turn back to Mr. Levin.
Thank you, Madam Chairwoman, and thanks for holding this hearing. Ms. Finlaw, thank you so much for coming. I appreciate you being here, you taking the time off. I saw your national president of the AFT here. I really appreciate the support of the organization to help us figure this out. let's just talk about this on a human level. So when did you go to school? When did you, what's your education about teaching?
I entered into a degree for art education in the fall of 2001. It's a 5-year program. I graduated in the spring of 2006. I started teaching that school year.
And so you have student loans from those years.
I paid for 100% of my own education. with
Awesome.
loans.
And so when did you become aware of this public service loan forgiveness program?
In the 2007 school year, it was a pretty common conversation amongst teachers. This is happening. This is happening. This could affect us if we stay in education. Some people don't go into education for the long haul. I knew right away that I would.
So how long have you been working on trying to make sure you were eligible and stayed eligible?
Since I started paying back my loans, which is when I got my job teaching in New York City,
Like 12 years ago?
14 school years ago.
14. Wow, okay. And so can you explain to me now why you're not eligible?
I'm not eligible because one of my loans is not a direct loan, and like 100% of the people that applied for this loan, we all have college degrees and know how to read. However, when Nelnet tells you that you're on track, and that's who is your servicer, and they tell you you have nothing else to do but to fill out a form every year, and that in 5 years, in 4 years, in 3 years, your loans will be forgiven, then you believe them.
May I ask you how much outstanding loan debt you still have?
I started with $120,000. I now have almost 90 at a 7% interest rate. If I pay this off myself, I will still pay $130,000 more dollars.
Let me just express on behalf of the people of the 9th District of Michigan at least, and hopefully most of your fellow Americans, how sorry I am that we've had this program and that year in and year out you have done your best, thought and been told by the loan servicer that you were on track and had done everything you were supposed to do, and we completely failed you. I'm really sorry.
Thank you.
I'm really sorry. How, based on your best understanding, what do you have to do now to be eligible? Do you think your payments now are eligible?
Well, I've been told that I was accepted by FedLoan as an applicant. They took my loans from Nelnet, and then they told me that you've been denied, and to reconsolidate, and then Nelnet was my new servicer once again, and I called and said, okay, so now I'm on the right payment plan, and the one loan that did not qualify is now a qualifying loan. What do I do? And they said, well, you just pay for 10 more years. And it's income-based, so we're going to quote you at $600 a month that you have to pay every month on these loans for the next 10 years, and if you get a raise, you're going to pay more. So that's what I'm in right now. That's currently what I'm in. Do I believe that I have to resign myself that I'm going to die with this debt? I have to just accept that I had to do this to get to where I am. I had no other option, and that's my reality, so that's what I accept. However, if a program was meant to protect me, I had to protect myself from this program, and I was unaware that that was going to be one of the qualifications of making it.
So they say that you're now on the 10-year track again, they claim that?
Yeah.
And you would have how long to go still out of this 10 years? 9.5, or where are you at now?
After I was denied, I went into forbearance to figure things out because I believed I qualified, and I wanted to make sure, like I wanted to not waste payments.
Right.
So after a year, I resigned myself that I have to go back into this, and I'm 5 payments in, so I have 115 more payments.
Which is 115 months.
Yes, yeah.
Yeah.
You can't,
All right.
you can't pay 2 payments in 1 month. You're not allowed.
Let me just commit to you that we're going to do our best to get to the bottom of this and honor our commitment to you. Our kids need you, and we need you to keep teaching. Thank you, and I yield back.
Thank you.
Madam Chairwoman.
Thank you. I now turn to the ranking member, Mr. Smucker.
Thank you. 2 points I'd like to make before I get to questions in regards to some of the comments made about FIA. The billion-dollar figure has been raised several times, dollars coming to FIA. I'd just like to remind members here that those dollars were grants for students. Those dollars were expended to ensure that students have access, have the ability to pay for their higher education. And secondly, I want to just point out that it is unusual. It is outside of common practice for this committee to call as witnesses the parties in an ongoing lawsuit. In fact, we don't know of any time in recent history, certainly in no time since I've been here, has that occurred. So just wanted to put that in the record as well. There is a lot to unpack here, from accusations that have been leveled in the media to the very real and very personal experiences of borrowers like yourself, Ms. Finley, and I appreciate you, Finlaw, and I appreciate you being here today. Their very personal experience of trying to earn that loan forgiveness, that loan discharge. I did notice that it's been voiced here several times, a commonly held perception that the PSLF program was a promise to all public sector workers, as if working in public service was the only requirement. And of course, we know that despite false advertising from wishful thinkers over the last decade, that's just simply not the case. For example, when the law was passed in 2007, and Democrats at that time made a legislative decision to tailor the program to direct loan borrowers only. But that's really only the tip of the iceberg when it comes to all of the eligibility requirements that have been placed on the program. Dr. Chingos, you seem to have a good understanding of those requirements, of the requirements that borrowers must meet to be eligible for both PSLF or the TPSLF loan forgiveness. Would you talk a little bit about the root cause of those issues?
Right, so the first requirement is having the right kind of loan. So back in 2007, only about 1 in 5 borrowers were getting a direct loan. And their college, not they, decided. So the terms were the same. They wouldn't know the difference. 2, you have to be in public service for 10 years, as defined by the federal government, and be able to document that full-time for those 120 months. And 3, you have to be in the right kind of plan. And the plans themselves have become more complicated over time. So I've talked a lot about the complexity of PSLF, but it really rests on a very complex, messy base of our federal student loan program, which is a really important program. It opens the gates to college to millions of students every year, but it can be really challenging to navigate because I've lost track whether we have 5, 6, 7 income-driven repayment plans, each with different requirements that work slightly differently and ultimately affect.
So would you agree that the root cause, the reason for some of these issues is that it is embedded in the requirements of the program that was passed by Congress?
I think the complex design of the program is an important reason why this has been so challenging, not just for borrowers to get what they were promised, but also for the federal government to administer it.
So we've been hearing the turning down of students as denials. Wouldn't it be more accurate to label those borrowers as currently ineligible?
The data we have certainly indicates that a large number of applications that have been rejected are because the applicant is not yet eligible. And I would expect in the coming years, folks who have not yet made the 120 payments are going to cross that mark and will be eligible.
Students, as we mentioned, are often unaware of the underlying basics of the aid that they're receiving. You note in your testimony that a study you did found 28% of federal loan borrowers in their first year of college didn't even know that they had a federal loan, and 14% did not know that they had any kind of student loan. 1/3 of students could not provide an accurate estimate of how much they had borrowed in the first place. Given that many borrowers do not have a good grasp of some of the basics of the federal loan system, I'm really not surprised that the PSLF and TPSLF approval rates are low. Are there ways that we could bolster our current loan counseling to help students and provide more of a positive solution?
I think it's definitely better to provide better information to people, but I think that's ultimately going to be a challenge because of the complex nature of the problem. So first, yeah, we should try and do that. But at the same time, for borrowers going forward, I think we need to think, can we make these programs better so that they work better without having to pay tons of money to some other company to have to then explain it back to the American people?
Thank you.
Thank you, Mr. Smucker. Before I turn to Ms. Adams in North Carolina, I just want to take the prerogative of the chair and just clarify that the $1.3 billion that we're talking about to FIA is just the payment that they receive for servicing the loans. So I want to add that to the record. Ms. Adams.
Thank you, Madam Chair, and thank you very much to all the witnesses for your testimony and for being here today. Thank you for the ranking member as well. I want to first direct my line of questioning to Ms. Chavez. Is that the correct pronunciation? First of all, I want to commend you and your office in your investigation into is that FIA. I know that Attorney General Josh Stein of my home state of North Carolina similarly attempted to request information from the Education Department to look into FIAs and PSLF practices, but was rebuffed. So can you describe the process that your office went through in investigating FIA's conduct and how the lawsuit was pursued?
I'll answer that to the best of my ability to.
Yes, ma'am.
Within the bounds of the litigation. But I think as a general matter, when we investigate any actor, we speak to borrowers who've been, or sorry, not to borrowers, but to consumers who have concerns, who raise those concerns to our office. And then we look at available information about what's going on, and we have the authority to file civil investigative demands, which are like subpoenas, to get information from the entities that we're investigating. We received information about FIA's practices through the course of that type of an investigation as we were figuring out what was going on before we filed this lawsuit.
Okay. All right, thank you very much. Ms. Finlaw, thank you very much for telling us your story. I share the sentiments and that my colleague expressed in terms of just feeling really bad about what happened and the fact that we do need to get to the bottom of it. And thank you for being a teacher. I taught 40 years at a college, Bennett College in Greensboro, North Carolina. My daughter is an assistant principal and has taught for 18 years. It is a noble profession. I can't think of anything that I would have rather done for all of those years. And like you, my degrees are in art education and multiculturalism, all three of them. So I appreciate the fact of what you do with students. I know what that is because I've done that. As someone who has been a teacher, I do know how rewarding that work can be, but I also know how long the hours can be, and how for someone who doesn't come from wealth, programs such as PSLF can be a godsend. So I imagine how angry you were when FedLoan told you that you basically threw 10 years of worth of payments down the drain. That's not only sad, but it's very unfortunate that that happened to you and to anyone else. So what advice would you have for others considering applying for public student loan forgiveness?
A friend of mine recently asked me that question, and what I would do differently now is the same advice that I would give to someone applying. I would keep every document you've ever been given, because I no longer have access to documents that were given to me. I would record every phone call when every person told me that I was on track and I was just years away, months away. I would get names and ID numbers of who I'm speaking with. And I would cover my own back in a program that was meant to cover my back. I have called FedLoan within the past 3 months, requested information, and been told certain information, and called back later and received different answers. So we talk about how this program can be approved and the guidance for the borrowers. Let's start with some accountability with our servicers.
Okay.
What information are they giving people, and how can I talk to 2 different agents within a 5-minute period and get different answers? And I would have all of that documented.
Okay,
Every person that's going to apply, document everything.
okay. So what do you hope that will come out of your lawsuit and your testimony today? We've got about 15 seconds.
Okay, the lawsuit is asking for forgiveness for the 8 plaintiffs on the lawsuit, but I don't want another teacher. I recently told my colleagues about this, what's happening, and I said, I hope that when you get to 10 years, that you don't have to sit where I'm sitting, that you don't have to look over your back or to answer for all of those things. My hope is that this program is fixed for you.
Thank you very much. I'm out of time.
Thank
Thank you
you.
very much
Thank
for your
you.
testimony. Madam Chair, I yield back.
Thank you very much. Mr. Watkins of
Thank
Kansas.
you, Madam Chair. Thanks for being here, everybody. Based on your insight, Dr. Chingos, about the extensive program criteria, could you please elaborate on what the early data tell us about borrowers who do qualify for forgiveness, and what would a borrower today have to have done to be eligible for TEP SLF?
So the first eligible payments could be made in October of 2007, so about 12 years ago. So in order for someone to be eligible today, they would have had to pretty much either have a direct loan back in 07, 08, 09, or have known to consolidate into one of them right away. They then would have pretty much had to remain in a public service job for the 10 following years, make those 120 qualifying payments. As we've talked about, those have to be in the right kind of plan, an income-driven plan, and they have to be on-time payments, not late payments, not early payments, on-time payments. So they would have had to check all of those boxes to be eligible now in 2019.
Okay, according to the GAO, 71% of TEPSLF applications were denied because a PSLF application had not been submitted first. However, looking beyond that, the remaining ineligible data is muddled. What is your analysis of the lesser discussed reasons why borrowers did not receive forgiveness? And what do the outcomes of borrowers in the other 29% of application rejections tell us about the scope and future of the TEP SLF program?
So if we look at the 29% of borrowers who met that first screen of having been applied and been rejected for PSLF, what we see is 35% had not been in repayment for 10 years. So if you haven't been in repayment for 10 years, you couldn't possibly be eligible, so they don't even look any further. 19% failed to meet the payment size criteria set by Congress when they created TEPSLF, those new requirements. 13% were below 120 payments, qualifying payments. 11% didn't have any eligible federal loans. 8% didn't provide the requested income information that Congress said they had to collect when they made TEPSLF, and a few other reasons, and then 4% were approved.
Thank you, Dr. Chingos. Madam Chair, I yield the remainder of my time to Mr. Smucker.
Thank you. Point of clarification, talked about the $1 billion in FIA. It is true FIA got paid in fees from the Department of Education, $1 billion. We're not denying that. But it's also true that FIA over the last decade has given back $1 billion to students in Pennsylvania. And the second point, the borrower on the panel has had interactions with multiple servicers, which sounds like some of those interactions happened before FedLoan became the exclusive PSLF servicer. So it seems that there have been obvious previous problems, and the previous administrations did not properly make sure that all servicers properly implemented the program. I think we will hear in the upcoming panel from the Department of Ed about steps that they are taking to rectify some of those issues.
Now move to Mr. Scott, Chair of the Overall Education and Labor Committee from Virginia.
Thank you, Madam Chair. If a student applies and is denied, it's probably the student's fault, but if 99% are denied, it's the program's fault. These aren't puzzles or contests. This is a program that you're supposed to benefit from. And having all these hurdles and barriers is just totally unreasonable. Ms. Finlaw, let me verify. You were told that you were on track by your servicer. Mr. Shingros, did you say 96% were ineligible?
Under TPE PSLF, if you met the first requirement, then 96% were still not eligible for TEP.
So we have a program where people think they're eligible when 96% of them are in fact not eligible.
That's right.
Ms. Shavit, what is the basis of your lawsuit, and what remedy are you seeking?
Sorry. Our lawsuit is alleging that FIA has mismanaged its servicing of the PSLF program, in addition to other servicing failures that we also allege, but relevant to this discussion. We're alleging that by denying borrowers the opportunity to make payments that qualify under PSLF, FIA is derailing borrowers' ability to benefit from the program. What we're seeking is that FIA will correct this problem, that it will ensure that borrowers who've been harmed are made whole. We are also asking that FIA take measures to ensure that the same problems that are harming borrowers now and that have already been a problem for public servants won't repeat themselves. We are asking FIA to ensure that it is changing its policies in a forward-looking fashion as well.
In the meanwhile, obviously we need a change in the program. Are those needed changes regulatory or statutory? And what would you suggest that we do?
I think as an initial matter, we have an important program that's been law for quite a while, and while it's complex, it's not impossibly so. The problems with this program came to a head in 2017 when it was clear that there was real servicing failure around the time that borrowers were first eligible to receive loan forgiveness, and the Department of Education didn't rise to the occasion to increase its oversight of FIA and its other servicers to ensure that borrowers weren't harmed. The program as it exists needs to be fixed. While there might be some statutory changes that could happen, first and foremost, the department needs to do what it is tasked by Congress with doing, which is ensuring that borrowers get the benefit of the PSLF program. And one thing that I might add is, given both the department and FIA's failures to fix these problems thus far, Congress might consider devoting some funding to a third-party auditor who could go through and review FIA's practices to actually identify what's going on that's harming borrowers and to audit individual borrower accounts to make sure that every person is identified who's been harmed and can get the relief that they're entitled to.
Are you familiar with the GAO report?
Yes, I am.
The GAO made recommendations.
Yes.
Are there additional recommendations that need to be addressed?
I think it's more oversight by Ed, and I think it's more responsibility for servicers. I think, as the department's Office of Inspector General noted, the Department of Education needs to actually create consequences for servicer misconduct. It needs to be willing to penalize its servicers when they're failing borrowers. That's, I think, not mentioned in the GAO report, but I certainly agree with the recommendations in that report as well.
Thank you, Madam Chair. I yield back.
Thank you. We now turn to the ranking chair, Ms. Fox of North Carolina.
Thank you, Chairman Davis. I want to thank our witnesses for being here today. Dr. Chingos, much of the hearing today is focused on what GAO has reported regarding PSLF and TEPSLF implementation and the experiences of borrowers navigating the repayment process. Lost in this conversation are some critical facts. The CBO's most recent baseline projects that under fair value, the direct loan program will cost taxpayers over $300 billion over the next decade. The CBO recently estimated that eliminating PSLF for new borrowers would save a projected $23 billion over 10 years. Student loan borrowers as a group are paying down about 1% of their federal student loan debt every year. As of the second quarter of fiscal year 2018, 45% of borrowers were in active repayment. 56% of borrowers owe less than $20,000 of student loans, and the top 6% of all people who borrowed had the most hold 23% of all the outstanding student loan debt. Taken together, these data tell me that taxpayers are about to be on the hook for billions of dollars borrowed by graduate students. Do you agree with this assessment?
Thank you for the question. So graduate lending is a big piece of the story here. So in the most recent data, we see graduate students are 14% of all students, but they borrowed 47% of the loans, so nearly half. So that's really where the big dollar loans are among graduate students.
If this is the case, what structural changes should Congress make to the lending and repayment programs to limit irresponsible borrowing and protect the interest of both students and taxpayers alike?
Well, I think Congress can take a look at the loan limits in the program. So one thing that happened around the time PSLF was put in place in 2007, within a couple of years, I think in 2006, Congress expanded the Grad Plus or created the Grad Plus program. So whereas undergraduates can't really borrow, it's pretty hard to borrow more than $45,000, and by law you can't borrow more than $57,500. But graduate students can borrow an unlimited amount up to the cost of attendance. And for a number of years, that sort of worked okay. The graduate loan program was maybe even making some money for the government. People were borrowing, but they were borrowing money that they could repay. But when you interact that with a loan forgiveness program that is potentially, if implemented, as generous as PSLF, you could create a situation where we're forgiving lots of debt, and we're not forgiving debt of people with $30,000 for a BA. We're forgiving debt for people with $150,000, $200,000 to be a doctor or a lawyer.
Right. Well, let's return to CBO's recent estimate that eliminating PSLF for new borrowers would save a projected $23 billion over 10 years. In your mind, is this another indication that the initial denial rate is temporary, and as more time passes, these eligibility issues will get ironed out and borrowers will navigate these rules more successfully?
Right, so we know from the GAO and the Department of Ed that not many applications for PSLF and TEPSLF have been approved so far, but I think it's pretty clear from the CBO saying that this is a program that's going to cost $23 billion over the next 10 years, that they expect a lot more people to be approved in the coming 10 years.
Thank you. I know some comments have been made about the Prosper Act, which we passed through this committee last session. Let me say that the main motivating factor in our eliminating PSLF going forward was exactly what we are hearing about today, and that is how complicated the law is and how unwieldy it has been for students. We didn't want to hurt students who wanted to get an undergraduate degree and go into public service. That was not the intention. The intention was exactly to solve the problem that's here today. And we believe under income repayment plans, students would have, we know, we did the numbers, would have been better off with a very simple loan program that was much easier to understand than it's clear is being described here today. I'd also like to point out that our witness has said that the department did not do what it should have done before 2017, and we certainly agree with that. I'd also like to enter, Madam Chairman, two other pieces into the record. These are graphics from the Department of Education, how to get your student loans forgiven, and then process for obtaining TEPSLF loan forgiveness, which puts in graphics what Dr. Shingus has been saying.
Thank you, and that's so ordered for the record. Thank you, unanimous consent. Ms. Bonamici from Oregon.
Thank you very much. Thank you all for your testimony. I have a consumer protection background, so I've been deeply concerned about the implementation of the Public Service Loan Forgiveness Program and the temporary Public Service Loan Forgiveness Program, and have been incredibly concerned about this being an empty promise to borrowers like Ms. Finlaw. Last Friday, I had a roundtable discussion to hear from Oregonians who have been affected by this. A lot of people showed up. What I heard, stress, uncertainty, and a feeling like these borrowers had upheld their share of the bargain. They told me about putting off getting married, putting off home ownership, putting off starting families, all because of the burden of student debt. And they spoke about their passion for public service. One of the borrowers, Sawyer, served in the military. She found out after paying her loans for 8 years, they told her she was in the wrong repayment plan. She had to start all over again on her 120 payments. There's a PhD psychologist who works at the federal prison. She loves her job. It's really hard. She's incredibly stressed because of the amount of debt she has from getting a PhD. Her payments are not even affecting the principal, so it's getting the debt is getting larger and larger, and the story she's hearing, she's really concerned about that. Other participants, some were told that they needed to consolidate their loans to participate, and others said they didn't qualify because they consolidated their loans. Many lost years worth of payments, like you did, Ms. Finlaw. One of the borrowers, Susan, said she and her husband tried for a year to get confirmation that their payments were qualified. One borrower, a teacher, had her loans forgiven under the temporary public service loan forgiveness program. I think she's one of 24 in the entire state, one of the 1% nationally. And she told her story. She said she had to fight tooth and nail. She said she doesn't have any kids. She used all of her spare time. She worked with my office. She worked with the Consumer Financial Protection Bureau, which I might note would not be particularly helpful at this period of time because President Trump recently appointed a FIA executive as the top student loan official at the Consumer Financial Protection Bureau. She worked with the Ombudsman at the Department of Education. She painfully detailed, as you recommended, Ms. Finlaw, every interaction she had about her loans. It took a tremendous amount of time and patience. This is certainly not what Congress intended when the Congress passed the original program or the temporary program. I'm really grateful for all of them, all the people who shared their stories in Oregon, and Ms. Finlaw as a big supporter of arts education. Thank you for your important work. I'm going to ask you a question, but first I want to ask Ms. Shavit, is there any information you can share about how FIA got this very lucrative contract to administer the Public Service Loan Forgiveness Program?
The information that I know is basic information. I'm sure that there's more detailed information available, but there was a process by which servicers competed to get the exclusive contract to manage this program. And I'll note that any complexity in this program was known at the time, and FIA represented, in order to get this contract, that it would be able to do its job and administer it. So, I think that's a critical piece of this, right? The representations made are that FIA is up to the task. That was the position I'm sure that they took in order to get that contract.
Thank you. And Ms. Finlaw, you've heard this morning that the FIA is not represented here today, even though they were invited and decided not to come. What would you have said to FIA and what would you like to tell the Department of Education about your experience? What would you say to them directly?
I think that it's interesting that if my principal called me into his office today and I just said, nah, I'm not going to show up, it would mean my job. And yet there's an empty seat next to me. And I'm someone that this organization deeply affected. And I don't get to look anybody in the eye. And that, he has to sleep at night. And all of the people that are going to hide behind legislation have to sleep at night. I sleep really well at night. My moral compass is strong. And I will be in school tomorrow morning at 8 a.m., greeting my kids at the door. And no one's going to take that from me. And I would go back and do it all again for the right to stand there every day. And I just wonder what he would have to say to me, what he would have to answer to me to say, hey, you didn't jump through every hoop. We know we told you. We told you did. But game's up, like you didn't follow every rule, like you got to the end and oops. Like, can you really look at me and say that? He's not here to do it.
Thank you so much for your work, for your passion, and for representing, I know, many others who are in the same or similar situation across the country.
Thank you.
Thank you, Madam Chair. I yield
Thank you.
back.
Mr. Klein of Virginia.
Thank you, Madam Chair. Thank the witnesses for being here. As lawmakers, we're tasked with ensuring that all legislation we pass out of this body is able to hold the test of time within the framework of the Constitution. And to that point, law should not be written in such a manner that compliance is proven to be extraordinarily difficult, particularly when the incentive is financial. I wasn't a member of Congress when the Public Service Loan Forgiveness Program was passed back in 2007. Unfortunately, PSLF and temporary expanded PSLF have seen dramatically low rates of full eligibility, even when the participants have such a large financial incentive to be in compliance. Since coming to Washington and joining the Education and Labor Committee, I've committed to ensuring that laws are and remain navigable. PSLF and TEPSLF were intended to benefit nurses, firefighters, police officers, teachers, and other workers who have devoted their lives to serving the public. In many cases, these brave men and women are putting their lives on the line for others in their communities. That drive and motivation to serve is part of what makes this country so exceptional, and we should recognize, commend, cherish, and empower all our citizens who work to make the world a better place. Instead of drafting PSLF for specific occupations, the majority designed and passed a program that delineated eligibility based on the tax status of the employer. So not all nurses and not all teachers were eligible for forgiveness, and depending on where they worked or how they had structured and were making their payments, their eligibility is even further magnetized. These are important distinctions that quite literally have very real costs associated with them. We need to have a serious conversation about solutions instead of attacking the administration for executing the law that Congress wrote. A law creating a web of confusing requirements will inevitably reward those borrowers most skilled at navigating such a complex process instead of the borrowers who may be more in need of relief. Dr. Chingos, in your estimation, do PSLF and TEPSLF as currently structured lay out an easy-to-follow path and help the borrowers who most need repayment relief?
I think a look at the requirements makes it clear that it's challenging. A look at the implementation of the program, a look at the fact that 99% of the people who think they're eligible are not, in fact, eligible. A look at stories like Ms. Finlaw's, which, frankly, it's angry to hear the stories like that. And so really my interest in all this is helping think about how do we design a program so that doesn't happen again.
And how has the complexity of compliance changed over the years?
I think it's become more complex. When the program was passed, around the same time they passed one of the, not the first, but I think the second or third income-based repayment program. We now have a new income-based repayment program. We have a pay-as-you-earn program. We have a revised pay-as-you-earn program. So the repayment system itself has become more complex, and because you have to be in that system to be eligible for PSLF. And then TEPSLF, of course, also well-intentioned, created a whole other set of requirements around certifying that your payment size was the right size over the last 12 months. And as we saw, a number of people were rejected because they didn't send that information or they didn't meet that requirement set by Congress.
So the PSLF program was enacted back in 2007, and the first time a borrower could verify they were somewhat on the right track for PSLF was after the department released the employer certification form in 2012. How did this long delay in getting the implementation of PSLF start to contribute to the problems and confusion borrowers are grappling with today?
I think that fact, it highlights a broader issue, which is that retroactive programs are really hard to implement. So it's one thing to say, okay, starting next year, we're going to change the loan program in this way. We're going to give a forgiveness to someone who does something next year. But to say we have to look back 10 years, that's why I think it has been important that the department over the last two administrations has worked to put those certification processes in place. But it's yet another example of how complicated and difficult it is to implement this program.
Thank you. Madam Chair, with that, I'm going to yield the remainder of my time, if she'd like it, to the ranking member, Congresswoman Fox.
Thank you very much. Dr. Chingus, would you state that again that you just said? Most of the time, those of us in education know that you set up evaluations to begin with. You don't go backwards and try to evaluate. Would you, because I think that's a very important point that you made.
Yeah, I think this is an area where I'd love to have more data. I really want to know, are there 10 Kelly Finlaws in the world? Are there 100? Are there 1,000? Are there 1,000,000? And GAO gave us a lot of data, but it didn't tell us anything about that. It told us about who applied and who was eligible. And what we really need to know is who is out there who is eligible for this program, and are we reaching them?
Thank you very much. That's very helpful.
Thank you. I want to turn now to Ms. Lee of Nevada.
Sorry about that. I wasn't expecting that. I thought you were going first. Thank you, Madam Chair. Thank you for all being here today. This issue is really important to me for two reasons. One, as a person who put myself through school with student loans and understanding the burden that it is placing on young people in our country, we have a student debt crisis. in this country. But secondly, in my home state of Nevada, we happen to have a public employee service crisis in terms of deficits in nursing, mental health professionals, and most importantly, teachers like yourself, Ms. Finlaw. We just started the school year with 700 vacant positions. This program, statutorily, we can talk about the law, et cetera, but was created to incentivize people to go into public service careers. And in this committee, unfortunately, we heard many stories. And I think about one in particular in my hometown, Carolyn Cortman, who worked for the Clark County School District. She took out loans in 1998 and thought she paid them off entirely. Turned out that she had $130 left. Then, as many teachers who seek a career advancement, she went on to get a certification in speech pathology, which required her to take out $25,000 in loans. And after that, she signed up for the teacher loan forgiveness program, another distinct program, but also one that's run by a loan servicer such as FIA. She went on to make her 6 minimum payments. And after that, she applied but was denied because of that $130 from 1998, which she had already actually paid off. And I'm sure, like you, she went through several iterations of trying to navigate the system. And finally, Nelnet told her that her servicer said essentially she should start and apply for the PSLF and start the clock ticking again for 10 more years. And given what we know now, I can't blame her for giving up at that point. Loan forgiveness programs, let's be clear, were intended to encourage people to enter public service. Ms. Finlaw, first of all, thank you for your commitment. Your children must be incredibly fortunate to have you as a teacher. Your story is just one that's all too familiar. But most importantly, it's really about mismanagement and confusion, and in the end, hardworking people like you not being able to adequately benefit from a program that was created to help you. I just want to understand a little bit more. Can you walk me through what was your process of applying, but more specifically, how many times did you call? What was the length of those calls, and where do you stand? You already told us where you stand now.
To be eligible for this program, you have to be on an income-based repayment plan, which means that every year you have to reapply. So every year they're reaching out to you and saying, you need to submit your taxes and proof of employment. That conversation happens every year. And in that conversation, I say, and this is putting me on track for PSLF. And me submitting this, is there anything else that I have to do? No, just keep paying. You pay every month, it's auto deducted out of your bank account, like you're on the right track. As long as you fill out that income-based repayment plan, like you're on the right path. In 2017, I received an email from Nelnet that said you are eligible to apply for public service loan forgiveness. You've done everything right. Then I was taken over to FedLoan. Nelnet was no longer my servicer. So Nelnet even said, don't pay anymore because your loans will be forgiven. FedLoan sent me a letter that said, essentially, too bad, so sad.
Clearly very confusing. Here's my question. You believe this was a government program and was operating in good faith. Did you, at any time, did you feel you were lied to or misled?
When someone earlier was speaking about other loan forgiveness programs, I was forgiven my Stafford loan. I was forgiven different loans. I had no reason to believe this wasn't going to work. I really believed that the couple $1,000s that had been applied to my loans would be forgiven because they had been so far. And yes, I was lied to several times, directly lied to. In fact, I was told to do things that in the end put me in a worse place.
Thank you for the answer. I'm out of my time. Thank you.
Okay. Thank you. Mr. Sablon?
Thank you very much, Madam Chair, for holding today's hearing. Good morning, good afternoon, I think, everyone. My two youngest are public school teachers. One of my daughter works at a county sheriff office too. So, but Ms. Finlaw, is there something that you'd like to say that you have not been given an opportunity to? Do you want to say something that for the record? And then I'll share it with Ms. Shavit.
Thanks for giving me that opportunity.
You're welcome.
It feels a lot as someone sitting in this seat that it's really easy to write me off under what Congress put into law in 2007. It's just really easy to say they made it really complicated. End of story, period. I did what I was asked to do. I called. I made my payments on time. I pay every month. And I was misled, not just by FedLoan, but by other servicers, and lied to. And in what other sector of government are you able to lie to the people that you're servicing and then hold them responsible for the lies that you told them? And so from someone sitting in this seat, it deeply affects my life, and it's just infuriating to hear someone say, well, this is what the law said. If that's what the law said, I'm going to back up what Mr. Scott said and say, then how did 99% of people misread the law?
Right.
Thank you.
I would probably throw a shoe against a wall, maybe on several occasions. Ms. Shavit, is there something you'd like to add for the record?
I'd like to reiterate the importance of this program. And I'd also like to say that, as Ms. Finlaw suggested, the complexity of a program shouldn't be an excuse for the department not to do what it is responsible to do and ensure that the program is administered correctly. I disagree with the notion that this is a uniquely complex program. I think what we see here is a failure of good faith on the part of the department to actually make sure that this program is implemented the way it should be, and it's a failure of responsibility on the part of servicers to make sure that they're doing everything that they need to do to make sure that borrowers are getting the benefits of the programs that Congress intended.
Thank you. Madam Chair, thank you. I yield my time back.
Thank you very much. Mr. Keller.
Thank you, Madam Chair. Just a couple things. Congresswoman Fox actually laid out a timeline and submitted items for the record, which I thought she very adequately pointed out the failures in what happened here in Congress and, quite frankly, in previous administrations in the Department of Education. A program that started in 2007 that was signed into law. Regulations came out in 2008, and the Department of Education didn't have an employer certification form until 2012. Certainly, we can't say that it's one loan servicer over the other when you have the confusion. I mean, we're talking about people that 98% of them don't understand how the program works. If you have all the loan servicers that don't understand how the program works, there's definitely a problem with the program. And rather than try and place blame on one of those individuals or another, I think this body ought to be looking on how we fix it and not how we place blame. Because certainly we can probably look at what happened with this law in 2007, and we can look at the Department of Education under previous administrations. Congress realized there were problems with it when in 2018 we had to have the temporary expanded public service loan forgiveness program. So Congress obviously knew that something was done incorrectly, and we did this. And I will say that the current administration is the one that signed that. And the administration or the loan servicers cannot make up their own rules. They should not, and they can't. They follow the rules they are given. This is serious stuff. It affects lives, it affects people. And these are certainty from their government, but here again, we can point to numerous things in both of these programs that have been failures because of the ambiguity created here in this body. So with that, I want to go to Dr. Shingos. There's a question I have, and you mentioned some data earlier and understanding that. How might the department use available data to predict participation in the PSLF and the TEPSLF? People that might be eligible for these loans so that we can target making sure they have the adequate information.
So the primary way the department can do that now is for the people who have come forward and identified themselves, started to fill out those employer certification forms, started to count those qualifying payments. They can keep track of those people. We could get maybe a deeper look into the servicer data on those people. I think there's more, reading the GAO report, I thought there was more that could be learned from the data that currently exists about people who are applying. I'm really interested in better understanding that 99% that's not being approved, understanding why, because it's a huge number of people. And it's easy for me to sit and say, well, maybe people are confused or don't understand it, but I think there's a lot more we can use the data to learn, why is that the case and what do we do about it?
Is there any other data that we're not collecting that you think we should?
So I think if there were a linkage between, say, IRS data and Department of Ed data, that would be an opportunity for the federal government to know things about borrowers it doesn't currently know. So if someone is working in the public or nonprofit sector, they'd get a W-2 from their employer with an EIN, and so that's over in the Department of Treasury and the IRS. If the Department of Ed knew that information, well, then they could do more proactive outreach to people to say, hey, you're in this sector, make sure you're doing the right things to be eligible for this program that you're entitled to. But right now, they're not able to do that.
Okay, I appreciate that. And a perfect example of how two federal government agencies aren't communicating, and yet we put out rules to loan servicers that obviously multiple over the 10 years or prior to people could apply, and now we want to go after the loan servicer of FIA simply because they're the ones servicing the loans now. So again, I just think that we need to not focus on who we contracted with, but why we made it so ambiguous that people don't understand it. Thank you. I yield back.
Thank you very much. It's now time to recognize myself for 5 minutes. I'm going to do that quickly, and then we will turn to the next panel. While we still have you with us, and again, you've all been very helpful. I wonder, part of the full picture here really does mean that we need to hear from the Department of Education. And I wonder, and we also have the GAO with us as well. I wonder if you could share with us, maybe just starting with Ms. Shavit, what you would like to know from them, what would be helpful in our further discussions to better understand the role that they've been playing and whether or not, in fact, there's something that they could have been doing along the line to communicate better with the Congress.
One thing that I would certainly like to know is what efforts are being taken right now in the Department of Education to make sure that borrowers like Ms. Finlaw are getting the benefits of the programs that they were reasonably relying on. I want to know what instructions the department is giving to FIA with respect to making sure that these borrowers are made whole, but I want to know what the department is itself doing or planning to do in that regard, and how it thinks that the program can be fixed going forward. I want to know what plans the department has to make sure that future borrowers who are willing to commit themselves to the public good will have access to this program. These are the primary pieces of information that I think we need to know. What plan is in place and what information needs to be gathered to make sure that people who are supposed to benefit from this program can.
Thank you. Doctor, we've been saying Chingos, Claire.
Chingos.
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 Okay, thank you.
Thank you.
Please, in just a minute or two, what is your sense of what would you like to know?
Sure, yeah, I would love to hear from, GAO, Department of Ed, what data would they need and how could they get it to more accurately measure how well PSLF and TEPSLF are being implemented? We talk a lot about this 99% rejection rate. It tells us something about the program, but it doesn't tell us what we really want to know, which is who's out there who should be getting this program, and are they getting it? And if they're not getting it, why? So I would really want to know what data could help us better assess that so that we can make improvements going forward.
Thank you. And Ms. Finlaw, what would you like to tell the Department of Ed, what would you like them to know that you haven't had a chance to say?
I would like to know what I'm supposed to do when I'm lied to. I would like to know what recourses I have, and in 10 years, what will I do then? I'd like to know who's looking to protect the borrower from these organizations that mislead and misrepresent, and who's going to protect me in the next 10 years? How do I know I'm not being lied to again if I'm doing everything I'm told to do?
Thank you. I want to thank all of you and certainly my colleagues who are here. This is often when we have a second panel, it makes it difficult because members have had to go into other committee hearings. And so I hope that the few of us who are here right now will have an opportunity to really understand and learn more. I've heard many different things. I mean, I've heard we should shelve the program. That, in fact, if people only read the Department of Ed's directions, that they shouldn't have any problem. I've heard that, in fact, it is complicated, and there probably are reasons why, in the process of even the initial legislation and on, as we know, it started in the Bush administration, went through 3 administrations, basically, and we still have a role on the part of the Department of Ed to be able to, kind of yell, help. We've got some problems here. We need to take a look at this. So that's what we want to know. I personally believe that as a country, this is something important for us to continue to do, to pledge and then to act on that pledge, that we're there to help along the way those people who go into public service and choose to make that their career, their lifelong careers, important for people to do, and not everybody is able to do that. We do have, I know that the issue of graduate students maybe have more wherewithal. Yes, some do, but probably the majority do not. And so we need to be able to address that issue and how we deal with it, how we make this work. And you've been very helpful in helping us understand that. Thank you. I now want to remind my colleagues, I have a number of things I have to read here, so just bear with me for a second. I remind my colleagues that pursuant to committee practice, materials for submission for the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing, preferably in Microsoft Word. The materials submitted must address the subject matter of the hearing. Only a member of the committee or an invited witness may submit materials for inclusion in the hearing record. Documents are limited to 50 pages each. Documents longer than 50 pages will be incorporated into the record via an internet link that you must provide to the committee clerk within the required time frame. But please recognize that years from now, that link may no longer work. What we have heard here today, of course, is very valuable. Members of the committee may have some additional questions for you. We ask the witnesses to please respond to those questions in writing. The hearing record will be held open for 14 days in order to receive those responses. I remind my colleagues, pursuant to committee practice, witness questions for the hearing record must be submitted to the majority committee staff or committee clerk within 7 days. The questions submitted must address the subject matter of the hearing. And we will now take a very, very brief minute or two to see our second panel. Thank you again. All right, thank you both for being here, for staying with us throughout the panel. I think it's helpful for you to hear them and for them to know that you're in the audience as well, and appreciate that. I wanted to now introduce our witnesses. Jeff Appel. Jeff Appel is the Director of Policy Liaison and Implementation at Federal Student Aid. Prior to joining Federal Student Aid in 2016, Mr. Appel worked in the department's offices of the Undersecretary as well as the Office of Planning, Evaluation, and Policy Development. Prior to working in the department, he worked on Capitol Hill as a senior policy advisor with the House Committee on Education and Labor. And prior to working for the committee, Mr. Appel worked at the Government Accountability Office, the GAO, for over 20 years, and for several years led much of GAO's higher education and student financial aid-related work. Next, Melissa Emery Aras, okay. Thank you, Ms. Ayers, is a director in GAO's Education, Workforce, and Income Security Issues team. She oversees GAO's higher education reports and has led studies examining the Public Service Loan Forgiveness Program. Before joining GAO in 2001, she worked at a private sector consulting company and conducted program evaluations for state and local governments. Pursuant to Committee Rule 7D, I will now ask the witnesses to please stand and raise their right hands. Thank you very much. Do you solemnly swear or affirm that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record show that the witnesses all answered in the affirmative. We appreciate, again, your being here and look forward to your testimony. I wanted to remind you that we have read your written testimony, your statements, and they will appear in full in the hearing record. Pursuant to Committee Rule 7D and committee practice, each of you is asked to limit your oral presentation to a 5-minute summary of your written statement. I also wanted to remind you that pursuant to Title 18 of the U.S. Code, Section 1001, it's illegal to knowingly and willfully falsify any statement, representation, writing, document, or material fact presented to Congress or otherwise conceal or cover up a material fact. Before you begin your testimony, please remember to press the button on the microphone in front of you so that it will turn on and the members can hear you. As you begin to speak, the light in front of you will turn green, and after 4 minutes, the light will turn yellow to signal that you have 1 minute remaining. And when the light turns red, your 5 minutes have expired, and we ask that you please wrap up. We will let the entire panel, both of you, make your presentations before we move to member questions. Please remember to turn the microphone on once again when you respond. I will first recognize Director Appel. Please begin.
Thank you, Chairwoman Davis, Ranking Member Smucker, and members of the committee for the opportunity to join you today. I look forward to discussing with you the Public Service Loan Forgiveness Program, which we call PSLF, its temporary expansion, and our efforts to help borrowers understand and navigate their complexity. In 2007, Congress created PSLF to forgive any remaining balance on direct loans for borrowers who make 120 qualifying monthly payments. Under the law and regulations, a qualifying monthly payment is generally one that is made on time under a qualifying repayment plan and while working full-time for a qualifying employer. While these requirements seem simple, the law and regulations surrounding PSLF pose obstacles to borrowers. Two such complexities are, first, not all loan programs qualify. In fact, only direct loans do. And when PSLF was enacted, the direct loan program was a much smaller program. In 2007, about 75% of borrowers participated in the non-qualifying FEL program, a choice made by a borrower's school. To qualify for PSLF, therefore, a borrower with one or more FEL loans would have had to consolidate them into a direct loan. The FEL program ceased making loans in 2010. Second, not all loan repayment plans qualify. Qualifying repayment plans for PSLF generally include the income-driven repayment plans, IDR plans, and the 10-year standard plan, which would pay off loans before PSLF would apply. Many borrowers don't choose qualifying plans because they're comfortable making their payment when not based on income, or would find a payment based on income unaffordable to them. In light of these complexities and other disqualifying factors, the number of borrowers who have, to date, been eligible to receive forgiveness is low, As of June 30th, about 91,000 borrowers have applied for PSLF, but only 845 have had loans discharged. $52 million has been forgiven. In 2018, to increase the number of borrowers who could receive loan forgiveness, Congress created a limited temporary expansion of PSLF, or TEPSLF. The expansion forgives the remaining balance on direct loans for borrowers who would qualify for PSLF, but for the fact that some or all of their payments were made under the graduated or extended repayment plans. In creating the expansion, however, Congress set other conditions. Under the law, these borrowers must demonstrate that their most recent payment, and the one 12 months prior to applying, was at least as much as they would have paid under an IDR plan. And like the original program, the temporary program limited benefits to borrowers who made 120 qualifying payments on direct loans, which excluded many borrowers who had failed program loans or the payments they made prior to consolidation. Congress also required the department to implement an application process for TEPSLF within 60 days of an enactment. Thus, we stood up the simplest application process we could within that short time frame. As of June 30th, we've received over 17,000 requests for expanded forgiveness. Of these, 681 borrowers had their loans discharged for a total of $28.2 million. While initial approvals have been low, we do expect that more borrowers will qualify for PSLF and its expansion in the future. Why do we expect this? Consider the following. Overall, among applicants with outstanding eligible loans, about 80% have not been in repayment for 10 years. Naturally, as time passes, more borrowers will have a real opportunity to meet the criteria of PSLF and the expansion. Regardless, we recognize that we must build on our improvements in administering the program. These improvements include implementing GAO's recommendations, which includes improving our communications and outreach, as well as streamlining processes. The GAO's recommendations were helpful to us, and we will continue to meet them moving forward. Beyond the GAO recommendations, we recently developed a PSLF help tool to help borrowers understand PSLF eligibility requirements. The tool allows borrowers to generate employment verification forms to make it easier to provide annual certification, and provides information about other actions a borrower should or must take if he or she wishes to receive forgiveness. Since launched in December 2018, borrowers have used the tool more than 216,000 times to generate over 82,000 forms. The help tool is a first step toward the type of service that we believe all borrowers deserve. To that end, we anticipate improving it as part of Federal Student Aid's NextGen initiative. The central focus of NextGen is to improve the customer experience throughout every stage of the student aid lifecycle. In short, we are committed to doing our job to help borrowers navigate the complex forgiveness programs the Congress established. We, as always, stand ready to provide technical assistance to you on any legislative change that would expand forgiveness to more borrowers who faithfully serve our country. In the meantime, we will continue to implement the law as written and continue to improve our administration of it. I appreciate the opportunity to provide you with an overview of our work, the changes we have made and plan to make, and welcome any questions you have today.
Thank you. Thank you. Ms. Harris.
Chairwoman Davis, Republican Leader Smucker, and members of the committee, I am pleased to be here today to discuss GAO's reports on the PSLF program and the temporary expanded loan forgiveness process. I will focus my remarks on three issues. One, the extent to which borrowers' applications for loan forgiveness through the PSLF program and the temporary expanded process have been approved or denied. Two, the extent to which education provides the PSLF servicer with sufficient information to administer the program. And three, opportunities for improving service to borrowers. Beginning with a look at the data on loan forgiveness, our 2018 analysis found that education had denied about 99% of borrowers that applied for PSLF during the first 8 months that education was accepting applications. According to education's PSLF data through March of 2019, PSLF program denial rates have continued to be about 99%. Similarly, when we looked at the temporary expanded loan forgiveness process, we found that education had denied 99% of those requests as of May of 2019. Turning to education's interactions with the PSLF loan servicer, we found shortcomings in the information education provided to the loan servicer, which increased the risk of administrative errors. For example, in our 2018 report, we found that education does not have a comprehensive document or manual to provide the PSLF servicer with guidance and instructions. This made it difficult to effectively administer the PSLF program and provide consistent service to borrowers, according to PSLF servicer officials. We reported that education's guidance and instructions to the PSLF servicer are dispersed in a piecemeal manner across multiple documents, including education's original contract, multiple updates to the contract, and hundreds of emails to the servicer. As a result, PSLF servicer officials said that their staff were sometimes unaware of relevant PSLF program guidance and instructions in emails provided by education. Consequently, we recommended that education develop a timeline for issuing a comprehensive guidance and instructions document for PSLF servicing. We also made recommendations to education to provide additional information for determining which employers qualify for PSLF and to standardize the payment information the PSLF servicer receives from other loan servicers for determining qualifying payments for PSLF. Education agreed with these recommendations, but has yet to fully implement them. Now turning to opportunities to improve service to borrowers, we have found that education can provide better service to borrowers by expanding outreach, streamlining processes, and sharing critical information with borrowers. For example, we found that education does not include information for borrowers about the temporary expanded process in key online sources. Consequently, we made recommendations that education include information on this process in its online PSLF help tool and require all loan servicer websites to provide information on the temporary expanded process. We also made recommendations that education integrate the request for the temporary expanded process into the PSLF application, provide borrowers with sufficiently detailed information to be able to identify any errors in the servicer's counts of qualifying payments for the program, and provide borrowers more information on options for contesting denials of temporary expanded loan forgiveness. Education agreed with these 5 recommendations and has yet to fully implement them. In conclusion, large numbers of borrowers have pursued careers in public service, sometimes at lower pay than in the private sector, with the hope of one day achieving loan forgiveness through the PSLF program. They have often had to navigate the PSLF program requirements with a lack of sufficient information from education, only to be denied 10 years later when they applied for loan forgiveness because their prior years of employment or loan payments did not qualify. In addition, some borrowers who were denied may not be aware that they may be eligible for loan forgiveness through the temporary expanded process, potentially missing out on this opportunity. Education needs to take action to better serve these borrowers and to help smooth their long road towards loan forgiveness. We continue to believe that implementing GAO's 8 recommendations would strengthen program administration, improve service to borrowers, and help fulfill the original goal of encouraging individuals to enter and continue in public service. Thank you.
To both of you, thank you very much again for being here. I'm going to turn to Ms. Jayapal for the first questions.
Thank you, Madam Chair. I do think it's unfortunate that the CEO of the Pennsylvania Higher Education Assistance Agency, which exclusively manages the public service loan forgiveness through FedLoan, is not here. I would have really liked to ask him questions, especially given that FedLoan's performance under its contract with the Department of Education has frankly been abysmal. Dr. Appel, you say in your testimony that as of June 30th, 2019, about 91,000 borrowers have applied for PSLF and 845 borrowers have had their loans discharged for a total of $52 million. You realize that that is a less than 1% approval rate, correct?
Yes, Congresswoman.
And you acknowledge that Congress provided an extra $700 million to help students who were enrolled in the wrong repayment plan, and yet the Department of Education dispersed $28 million to forgive 681 borrower loans?
Yes, Congresswoman.
And you acknowledge that the Pennsylvania Higher Education Assistance Agency, or FedLoan, has made $1.3 billion over the course of 10 years to service student loans, correct?
Off the top of my head, I don't know the sum of the compensation they received.
But it sounds about right?
I wouldn't want to
Yes.
Okay, I'll tell you it is right, but you're aware that Mark Brown, the head of the Education Department's Office of Federal Student Aid, called Fed Loans performance, quote, wholly unacceptable, end quote, in an April 2019 letter to the company?
I haven't seen the letter. I will take your word for it.
Actually, Madam Chair, I'd like to enter into the record that letter from Mr. Brown. I'd like to ask unanimous consent. Thank you. And based on these facts, Mr. Appel, how would you grade Fed Loans' performance under its contract?
Well, among the, if we were to go over some of the facts that you laid out, you mentioned the reflected, and what I also mentioned in my oral statement and in the written statement we've submitted, the approval rate is low. But I think in the earlier panel, there were questions about the terminology sometimes being unfortunate.
I understand, and I'm so sorry, I just have a little bit of time, but if you had to grade Fed Loans' performance, how would you grade it on an A to F grading system?
So, Congresswoman, the current contract process that is used to allocate loans among new loans among servicers is based on a performance metric. In other words, as borrowers take out new loans and those are allocated among servicers, those are based on their performance against a set of metrics that include keeping loans in repayment,
I'm gonna
as well as customer borrower satisfaction.
I wanted to see if you were willing to endorse what Mr. Brown said in his letter. He called Fed Loans performance wholly unacceptable. I wanted to see if you were willing to say that. Has the Department of Education ever issued a corrective action plan to Fed Loan or to its parent company, the Pennsylvania Higher Education Assistance Agency?
I believe FSA has issued corrective actions with respect to a number of servicers.
Mm-hmm. And I'll just say in the letter that I submitted, there are 3 outstanding corrective action plans. 1 around deficiencies for improper servicing, 2 around customer service as identified in Higgins v. Education, and 3, the implementation of the TEACH grant reconsideration process. The fact that these warnings were even issued, I think, shows serious malfeasance at Fed Loan. Has the Department of Education compensated the borrowers who were affected, or did you require Fed Loan to do so?
I don't know about the particular circumstances that you're referencing. I do know when there are cases of servicer error, there can be corrective action that requires keeping borrowers whole.
Okay. Has the department ever considered taking all or a portion of business away from Fed Loan to improve the borrower experience?
As you may be aware, Congresswoman, FSA is now engaged in a significant effort to remake and transform the student loan servicing function as part of its Next Gen initiative.
And do you believe that Fed Loan should be under consideration for an ongoing contract, given that it's been called wholly unacceptable in terms of its performance so far?
So the acquisitions process that's common across the federal government includes provisions that require solicitations to be open for competition. That will be, past performance will be judged based on the requirements of that solicitation.
Thank you, Mr. Appel. It's unfortunate and I think very disturbing to me that $1.3 billion in taxpayer money is potentially going to be continued for an agency that has wasted that money as far as we can see from everything that has been put forward, and I hope that you would reconsider that at the Department of Education. Thank you, Madam Chair. I yield back.
Thank you. Mr. Smucker, the ranking member will now ask questions.
Thank you, Madam Chair. Mr. Powell, I'd like to just get a few questions and your answers on the record. So, yes or no, does the Higher Education Act, which is, of course, the act which authorizes PSLF, have specific criteria for borrower eligibility?
Yes, Congressman.
Does that specific participation criteria include employment with specific types of organizations doing specific types of work, yes or no?
Yes, Congressman.
And does the specific participation criteria include specific requirements about what counts as a payment for PSLF?
Yes, Congressman.
And does that criteria include a requirement for a borrower to be in a certain type of repayment plan and how many payments need to be made to qualify for participation?
Yes, Congressman.
Did the Department of Education add any requirements for participation in addition to what was already in the law?
There were some additions as a result of regulations developed by the department.
Could you go into detail about what some of those requirements may be, when they were established, and have any of those eligibility requirements been changed in the last decade?
So the Department of Education originally engaged in negotiated rulemaking to develop regulations for PSLF in 2007. I believe the final regulations were issued in 2008 in defining eligibility requirements. And on-time payment is defined as a payment within 15 days of the due date. There are also requirements that address certain types of qualifying activities within work performed by certain types of organizations. So, for example, certain religious activities might not qualify under the program as for employment purposes.
So again, your testimony is that those regulations were implemented in 2008?
Yes, sir.
Have any of those requirements changed since then, in the last decade?
There are a few additions that I believe were added in 2015 that pertained to making some exceptions about how to count payments for Department of Defense loan repayment programs that were kind of given a special treatment in terms of how those payments would be counted.
Thank you. Let's go then to the requirements for the expansion, the temporary expanded PSLF. Were those requirements as specific as PSLF?
Yes, Congressman.
Did the department add any requirements to the temporary expanded PSLF criteria when implementing that program that are not related to the statutory requirements?
No, Congressman.
Thank you. Mrs. Emery-Harris, also a few specific questions, yes or no. In the report issued by the GAO, did the GAO find that the department was not following the law on TPSLF?
We did not do a legal compliance review.
So there was no finding that they were not in compliance with the law?
Correct.
Did the department disagree with any of your recommendations in the report because they did not want to help borrowers?
The department agreed with all of the recommendations.
And did the GAO find that the department was actually completely denying any eligible borrowers?
No.
Did the GAO do any analysis of whether the law as written is the reason that almost all applicants for the program have been found ineligible?
No, our focus was on the implementation of the law and how it was operationalized by the department.
Thank you. And I'll yield back the balance of my time.
Thank you very much. Mr. Scott?
Thank you, Madam Chair. As I said earlier, I mean, we didn't create a puzzle or a contest. I mean, the odds of somebody getting through this process, I mean, they'd be better off buying lottery tickets. Ms. Apple, when should a person know that they're on the right track to get a discharge under this program?
So, Congressman, to help borrowers know whether they're on the right track, the department developed an employment certification form back in 2012 that we encourage borrowers to complete at least annually or more frequently if they change employers. And that starts a process that allows them to track their progress towards forgiveness.
Okay, and is that form sent to the servicer or to the department?
So the form is sent to the servicer. It's made available on our website, and borrowers can obtain the form from any loan servicer.
And as soon as the student, the borrower fills out the form, when do they know whether they're on the right track or not?
So when they, after they complete the form, if it's accurate, completely filled out, The contractor will review and respond to the borrower typically within 30 to 45 days. Depending on whether the form is complete, it can take longer if there's any back and forth required to obtain more information.
And so the borrower should know when they sign up with an employer whether they're on track to a 10-year discharge.
So one of the things that we've, in addition to the employment certification form that we've recently developed and implemented, is a public service loan forgiveness help tool. And it's an automated tool that will guide a borrower towards the steps of completing the employment certification form. But it's almost an online tutorial that will help guide borrowers to recognize, we think, sooner and make sure that they're aware that they have the right loan, are in the right repayment plan, that their employer is likely to qualify or may qualify. And those are some of the, we plan on actually making additional improvements to that tool in response to some of GAO's recommendations.
If that process starts taking place, what portion of the people who think they're in the plan will actually be in the plan?
So as we've kind of seen in some of the results to date with respect to applications that have been submitted, among those that have been found not eligible, several are because borrowers are not in the right repayment plan. Some of the new information that we've been making public is to help provide some transparency and clarity about those factors that are keeping borrowers from.
Now, as I understand, if you're in the wrong plan, you can consolidate into the right plan, right?
So if you have the wrong type of loan, you can consolidate into the direct loan program. For example,
And then you would qualify for the 10-year discharge.
you would have an eligible loan. Beyond that, there are other requirements beyond having the right kind of loan. That includes being in the right repayment plan.
Well, I guess the question is people ought to know whether they are going to get a discharge after 10 years. We all have constituents who have said they thought they were in the right plan. They're in the 10 years. They thought they had done what was necessary. And all of a sudden they're told, no, you've got another 10 years to make payments. That wasn't what we expected when we set up the program. Now, to fix this so that people who are in plans and have done what they're supposed to do we need statutory changes, or can this be done through regulation to fix the problem?
So depending on what problems or barriers.
Well, the problem is that 99% of the people that are applying for a discharge are told they're not qualified. And, you know, if it was 99% qualified, 1% didn't get it right, you could say it was their fault, but 99% discharge, there's something wrong with the, well, let me ask you this. Do you think there's something wrong with the program?
Congressman, earlier in my oral statement and in my written statement, we have information to the point of the low approval rates to date. So among applicants who have eligible loans, the right loans, about 80% have not been in repayment for 10 years. So meeting that 10-year repayment requirement is a significant criterion in order to earn forgiveness. So,
well, my time is expiring. Is there anything that to get this thing fixed, is there anything that needs to be done by statute, or can you do it by regulation to fix the problem?
Mr. Chair, I'm going to go ahead and go to the next member, but I also want you to respond to that in just a few minutes, okay?
So as I mentioned earlier, some of the obstacles borrowers are facing are because of the statutory requirements, and the department is happy to provide Congress technical assistance if you'd like to contemplate legislative changes. There are steps that we're taking to improve our administration of the program, some of which are in response to the GAO's recommendations. We're taking quite a few steps to try to increase borrower awareness about the requirements of the program and the steps that they need to take in order to earn forgiveness.
Thank you, Director Apple. Be back to you. Dr. Fox.
Thank you very much, Madam Chairman. Ms. Emery-Harris, the GAO completed a report in August of 2015 that said the Department of Education could do more to help ensure borrowers are aware of repayment and forgiveness options. In general, that report found that participation in the available programs was low, and the conclusion of that report says the borrowers needed information on PSLF to take advantage of the program. The report also found the department had not assessed the efforts it had made to raise awareness of the program. Is that generally accurate about that 2015 report?
Yes.
Ms. Emery-Harris, who was the Secretary of Education at the time this 2015 report was issued?
The prior administration.
Who was the Secretary of Education during the time period looked at in developing the report? How long had that individual been in that position?
It was under the prior administration.
But who was it? And how long had that person been in the position?
I don't remember how long at that point in time.
Okay. Well, I'd appreciate if you could get that for us for the record, okay? Mr. Apple, you were at the department when this report was issued, correct?
Correct.
In that 2015 report, the GAO noted that the department had taken some steps intended to increase borrower awareness of PSLF, but it had not notified all borrowers who have entered repayment about the program. The report noted that borrowers had to proactively seek out the information on PSLF that the department had put on social media and its website. The report goes on to note that the department was considering an email campaign to borrowers on income-driven plans. Mr. Appel, do you recall what actions the department took in response to this report?
So after, consequent to that report, the department continued some of the direct outreach it was making to borrowers as part of a campaign to increase awareness of income-driven repayment and the link of participating in that plan to public service loan forgiveness.
If the department had done more to inform borrowers earlier about all of their obligations under the law, would the ineligible rates we are currently seeing have been this high?
So I think one of those, Congresswoman, one of the significant and important details that we're offering today is in terms of insight into the low approval rates is the fact that a large majority of applicants haven't been in repayment for 10 years. Right. So there's either a confusion on the part of the borrower about what's required or borrowers are going ahead and applying, perhaps thinking they're taking the right steps in order to track progress.
Right. And nobody in the last panel or this panel has said one word about student financial aid officers and what is their responsibility to the students in terms. And again, one of the things we did in the Prosper Act was to talk about the financial literacy aspects and the importance of counseling to students. It seems to me that there's a big gap here in the people who are not here. We talked about FIA not being here. We should have had somebody from NASFA here to talk about what's the role of financial aid officers in explaining this to students. I will still contend students from the material on the department's website could understand what the requirements are. And I do think it's important for us to stop using the word denied and start saying ineligible, because as you say, 80% have not even paid 10 years worth, which means they're not denied, they simply have not become eligible for the program. And I think it's very important we do that. If the department had done earlier, a more robust outreach, I believe we would not have seen so many people incorrectly believing they were eligible and on track, but I also believe there would be very few people eligible for a discharge in 2019, considering all the limitations included in the law. There would have been no need to create TEP-SLF if Democrats in Congress in 2007 had done a better job writing the program, and if Democrats in the executive branch cared about borrowers enough to move forward with implementing the program so everyone was aware of the legislative requirements from the beginning. Most of these problems stemmed from the beginning of the program and the lack of work done during the Obama administration. And that simply is, the blame is being put on this administration which is incorrect. Thank you. I yield back.
Thank you. I turn to Mr. Saban.
Yeah, thank you, Madam Chair. We're all getting hungry. I'll get right to my questions. Mr. Appel, did I get that right?
Yes, Congressman.
Mr. Appel, why does the department prevent prepayments from counting towards public service loan forgiveness through pay-ahead status? And why wouldn't the government want to encourage borrowers to pay their loans early?
So, Congressman, I mentioned earlier one of the few additions to the statutory requirements that the department had added through its regulations was to define what constitutes an on-time payment, and that was a payment within 15 days of a due date. The idea behind that in part rests with the goal of the program and the requirement that a borrower's employment, that the 10-year service requirement is tied to their loan repayment. So there's kind of two subparts of that requirement. A borrower needs to work for 10 years for a qualifying employer, but also make 10 years worth of repayment.
Fair enough.
You've kind of combined that those two elements are kind of combined in that one statutory.
Fair enough, thank you. And Mr. Appel, on page 9 and 10 of GAO's report, they talk about the benefits of integrating the Public Service Loan Forgiveness Program, PSLF, and the temporary expanded PSLF, which allows borrowers to qualify for loan forgiveness through additional types of repayment plans. And it says that the department basically knows that this should happen. However, GAO says that there, and I quote, currently no specific plans to do so. How is that possible?
So I think, Congressman, to make sure I understood your question, the GAO did recommend that we combine the application process of both the Public Service Loan Forgiveness program and the temporary expansion of that program that Congress created. When Congress first passed the temporary expansion in 2018, they gave the department just 60 days to implement a simple process. We did the best we could within that short time frame. It's a challenge for a federal agency to implement anything in 60 days and comply with other statutory requirements, frankly, including the Paperwork Reduction Act. The simple process we think we've set up is really basically a borrower sending us an email. And given the statutory requirements in the appropriations language that conveyed that program, we felt, obviously legally, we had to make sure that a borrower wasn't first eligible for public service loan forgiveness before using the discretionary appropriated funds included in the appropriations bill. Also, by making sure that we're kind of using one pot of money before we use the discretionary pot of money, we would make those funds go further anyway. So we thought that was part of the goal of Congress as well.
So Mr. Appel, are you saying that GAO's statement that there are currently no specific plans to do so to merge, for example, the two programs is incorrect?
So I'd say their report and recommendation are fairly recent. I believe your final report just came out a week or two ago and includes that recommendation. We agreed with the recommendation. We don't have a time frame yet. One of the challenging things about trying to combine the two processes, frankly, is with the appropriated discretionary funds that pay for the loan forgiveness part of the bill, is dealing with the first come, first serve requirement. So there's a queuing process that is part and parcel of the temporary expansion.
I have one more question, Mr. Appel. Thank you. Mr. Appel, we know that the department itself has found that the loan servicer responsible for administering PSLF, the PHEAA, that the loan servicer has miscounted payments towards PSLF contrary to their contract. Has the department ever penalized PHEAA for not following its contract? And if not, why not?
So I'm aware that the department has developed corrective action plans to work with FIA on payment counting issues. I'm not sure of the specific requirements of that. I'm happy to get back to you on that if you'd like.
There's potential possibility that they will be penalized.
So the department in the past has taken actions against servicers that impose penalty. It includes recouping funds that they were paid to perform a service that we find they actually didn't perform.
My time is up, Madam Chair.
Thank you. I'm going to turn to Mr. Guthrie.
Thank you, Madam Chair. Thank you for convening this hearing. I appreciate it. I apologize. There's a couple of, I know another committee, and they had a couple of subcommittees meeting and been there, so I apologize for being late to be here, but glad to be here to ask some questions, look for your responses. So, Ms. Emery-Harris, this July, the GAO completed another report relating to federal loan repayments. In the report on income-driven repayments, the GAO found potential fraud in the program and suggested the Department of Education was vulnerable because of the weak verification measures of income-driven repayments. Is that correct?
That is correct.
So do you all stand by your findings and notes of potential fraud in this report, which you said you do? Do you believe Congress should be concerned about these deficiencies and that we should be looking for solutions to what you discovered?
We did make recommendations in that report that you referenced to help address potential fraud and error in the income-driven repayment plans.
Okay, thank you. So, Mr. Appel, was the department's reaction to that report on income verification and income-driven repayment plans, I mean, what was the department's reaction, and did the department make any changes, or are they in the process of making any changes to eliminate or mitigate the risk of fraud in these repayment plans?
Thank you, Congressman, for the opportunity to respond. We agreed with GAO's recommendations in that report and are in the process of taking steps to respond to those. We're still trying to figure out how best to do that. One of the things that GAO found, and that kind of highlights one of the challenges we have in implementing income-driven repayment programs, which has some impact with respect to the Public Service Loan Forgiveness Program, is that the department doesn't have access to income of borrowers unless borrowers provide it to us. That is sometimes an implementation challenge in terms of not only enrolling borrowers into an income-driven repayment plan, but maintaining their enrollment, because there's a requirement that they certify their income annually. We've taken steps to try to facilitate borrowers' provision of that income by using the same tool that we've used to help FAFSA applicants provide IRS data to the department for the purposes of applying for federal student aid. So that's the IRS DRT tool that you may be familiar with.
Right.
So borrowers can also use that for providing their income data for purposes of participating in an income-driven repayment plan. There are times, of course, that we know that borrowers may lose a job and their financial circumstances change, and they may not be earning any income, and they're still entitled to participate under the law in an income-based repayment program. And they may have payments that are legitimately $0. We're taking steps based on the GAO's findings that there seem to be a potential for fraud, or an indicator of fraud, given the extent to which they found that for some borrowers who had certified on their applications that they had very large family sizes or low or no income, that GAO found that they had earnings reported in the Department of Health and Human Services news hires database. another source of income information to which the Department of Education does not have access.
Okay. One other question, Mr. Appel. In order to prevent fraud in any program, it's important to carefully follow the law as written, as the department has done in the public service loan forgiveness. Further, I just want to, are you aware of any concern of potential fraud in the temporary expanded public service loan forgiveness or public service loan forgiveness, as the GAO noted in the income-driven repayment report?
So, Congressman, I'm not aware of any potential for fraud, but as I mentioned earlier, because of the issues that GAO had identified with respect to those borrowers that participated in income-driven repayment, being enrolled in it in order for a borrower to really benefit from the public service loan forgiveness programs, they need to be in an income-driven repayment plan that lowers their monthly payment more than a 10-year standard plan would provide. So to the extent that the information provided isn't accurate, then that's kind of a spillover from the potential concerns that GAO had about whether there's a chance of fraud.
Okay, thank you. My time has expired, and I yield back. I appreciate your answers. Thank you.
Turn now to Mr. Grothman. You ready?
Okay.
Thank you.
Mr. Appel?
Yes, sir.
Okay. There's a lot of confusion about the PSLF eligibility requirements. We should have a graph coming up here. Is there a graph coming up? Oh, here it is, behind me. Okay. I want to make sure I understand everything here, and I think even looking at this graph is going to lend credence to the idea that Congress did a bad job of putting this program together and it's too complicated. But are you familiar with this graph?
Generally.
Yeah. The graph to me looks ridiculously complicated. Do you think it's ridiculously complicated?
So, Congressman, in my written statement, we've kind of laid out what the statutory requirements are.
I'm not blaming you for it. I'm blaming Congress for it. I think the people who put together this program in 2007 didn't do a very good job. But you think that's an accurate statement?
Congressman, as we've mentioned, there's a relatively low approval rate, and we've identified several of the statutory criteria as being responsible for why borrowers aren't obtaining forgiveness on their loans yet.
Right, and I want to qualify myself. I mean, I asked the previous panel, I am not for programs that discriminate against people who decide to go into manufacturing or agriculture or the private sector. I'm not one of those private sector haters who thinks, you know, they should be left out of everything. But in 2007, a large percentage of students had been borrowing federal loans through the FFEL program, not direct loan, correct?
Correct. About 3/4 of students at that time were participating in the FFEL program because their schools participated in that program.
Yeah, and you think what happened is, or part of the problem is here, that the expectations were raised for people who are taking out their loans for the FFEL program, and that's maybe a primary reason why we don't have this huge forgivenesses that some people thought?
I think we Congressman, find in terms of reviewing the applications that have submitted that one of the factors that are disqualifying applicants from receiving forgiveness is the fact that they have FFEL loans, which don't qualify for forgiveness.
Okay. Probably millions of people have either FFEL or combined FFEL and direct loans, right? You think millions of people are in that boat?
So the FFEL program ceased making loans in 2010. It's a declining share of the overall outstanding balance of federal student loans.
But still a high percentage. You have
but
any
not insignificant.
Not insignificant. Over half?
It's less than half of the current outstanding balance at the time.
The balance, but the number of people who have some loans in that from those programs.
Congressman, it's also a declining share.
I know a declining share, but people who have at least...
It is millions of borrowers.
Millions, right. Congressman. Did the department say anything to those students during or after the transition about what that meant for repayment as we flipped from FFEL to direct loans?
So part of our outreach and communications effort that we do is intended to be to reach as broad an audience as possible. That's in part why we rely on social media in order to reach as many people as possible.
Do you think there were a lot of people who didn't combine or blend their FFELs into direct loans? Is that part of the problem too?
Congressman, that is part of the problem in the sense of that's what we see as we're reviewing the applications borrowers are submitting to date.
Okay. If a borrower over or underpays in any given month, will that still count as a qualified payment, assuming the borrower is in the correct repayment plan?
It depends if it can. That has been an issue for some borrowers, and we are looking at taking steps to help those who may have inadvertently overpaid 1 month. That causes their payment bill the next month to decline to an amount that was lower than their regular scheduled monthly payment.
Okay.
So there have been some issues.
Then I want to point out another area where we might wind up people disappointed. Okay. Now to get the PSLF, you have to be working for a nonprofit or government agency, right?
No, Congressman. Yes, Congressman.
Okay. Okay, so that seems odd. So if I'm a journalist for NPR or a journalist for the Washington Post, theoretically you're doing the same thing, but it's not occupation, it's employer, right? So you can have the exact same job, but because one guy was, or gal was, got involved working for a private sector corporation, they're out in the snow. And could that cause part of the confusion too? People didn't realize.
Mr. Grothman, your time is well up. Mr. Appel, could you respond quickly to the first part of that question?
Yes. For an employing organization to be eligible, it needs to be nonprofit or government. For-profit organizations would not be.
Could be confusing. Thank you.
Thank you. Thank you. Ms. Adams.
Thank you, Madam Chair, and thank you to the witnesses for being here. Mr. Appel, thanks for appearing before the subcommittee today. That's more than I can say for FIA. But we know that the department itself has found that FIA has miscounted payments toward PSLF, contrary to their contract. So has the department ever penalized FIA for not following its contract, and if not, why not?
Congresswoman, thank you for your question. I responded to a similar question earlier. I'm aware that a corrective action plan had been developed with respect to FIA on payment counting issues. I'm not familiar with the specifics of that. It's not a function that I directly oversee at Federal Student Aid, but I do know there was a corrective action plan taken. I know with respect to some servicers and others, there are penalties and consequences provided in cases where it's necessary. That has included reimbursing the federal government for fees they've been paid to perform services that we later find they failed to perform.
Okay, so you're saying that they reimburse as a way of correcting?
That is a method of one of the consequences of failing to perform as contracted.
Do you know if there are others?
There are other examples, I believe, of that being the case for other servicers on other issues.
Thank you. Ms. Amory Aris, the department seems to lay a lot of the blame on application denials on the borrower, either because they were not in repayment for the required 120 months or their applications were incomplete. In GAO's estimation, how much of that can be laid at the feet of the department and FIA?
I think any confusion at the level of the borrower relates to the need for outreach by the department. If people are applying for a program that they're not eligible for, it's because they're confused. And so it's really important that the department help them understand what the requirements are so that they can apply if they are eligible and not spend their time applying and have their hopes dashed if they are not.
So now that the department has begun implementing some of your recommendations, have we seen denials decrease accordingly?
It's still early, but the numbers have been very consistent in terms of the extremely high denial rates.
Okay, so it's more so than it was?
The denial rates have stayed constant at 99%.
Great. Thank you very much, Madam Chair. I yield back.
Thank you. Mr. Comer?
Thank you, Madam Chair. Mr. Pell, the legislative language that created TEP-SLF says, and I quote, "Provided further that the Secretary shall provide loan cancellation under this section to eligible borrowers on a first-come, first-served basis, based on the date of application and subject to both the limitation on total loan volume at application for such loan cancellation specified in the second proviso of the availability of appropriations under this section." My question, does the first-come, first-served aspect of the law incent borrowers to act quickly rather than take the time necessary to understand their obligations under the law to be able to receive assistance under this program?
Thank you for the question, Mr. Congressman. It seems we see an awful lot of applications that have been submitted among borrowers who have not yet been in repayment long enough to qualify. Because the first-come, first-served feature of the law was a key criteria in the statute, it is one of the things that we've advised borrowers about in the information that we've posted and made available to them with respect to how to take advantage of the opportunity.
So it's safe to say that the incentive to act quickly caused people to apply for the program without knowing whether they were actually eligible or had met all the requirements to be eligible. Is that correct?
That potentially could be a factor in motivating applicants to apply sooner rather than later.
Ms. Emery Aras, I know I probably mispronounced that. I apologize.
Okay, close enough.
Would you agree that the GAO has issued a number of reports over the years that include a finding that the Department of Education could have better informed their grantees or stakeholders about the programs or requirements in a program?
We have found that the department did not regularly inform people about PSLF when they were entering repayment. We also found, and we actually still have an open recommendation to this day, that the department still does not regularly notify everyone in repayment about income-driven repayment. That has been open for years.
Right, so yes. By our quick review, we found more than 20 reports dating between 2007 and 2015 that included a finding along those lines. Now, given your expertise in this field, would you agree it's clear that the Department of Education has historically done a pretty bad job of providing clear information to its stakeholders?
We've had concerns over the years.
Right. Would you say it's clear Congress should have known that the department, let's say, struggles with providing information to people?
I would say our reports have talked about that over time.
Right. So, to both of you all, would you both agree that if Congress wanted to ensure TEP-SLF was implemented in an easy-to-understand and straightforward manner, Congress could, and I would say should, have taken that body of GAO evidence and written a law that at least attempted to mitigate these known issues with the Department of Education under the Obama administration?
For GAO, that would be a policy call that we would leave to the Congress.
Mr. Pell.
Congressman, I work at Federal Student Aid, which is, we also don't do policy. That's the prerogative of other parts of the department. I would say that a requirement to implement a program within 60 days
is not a lot of time. So that's why we first established it the way that we did, and we did try to simplify the process for borrowers as much as we could within the time frame given. And with respect to the requirements for a borrower to let us know that they're interested in TEPSLF, the requirement and application process is basically sending us an email with their name and date of birth. That was the requirement to start the process. If they hadn't applied for PSLF yet, we required that they do so, since we needed to make sure that before we spent the discretionary appropriated funds, that the borrower was ineligible for PSLF.
Gotcha. Great. Thank you, Madam Chairman. I yield back.
Thank you very much. I think everybody who wants to ask a question has asked a question. So I will ask my 5 minutes of questions. Again, thank you for being here. Mr. Appel, you obviously sat here during the testimony earlier, and I'm wondering, as you listen to Ms. Finlaw, what did she do wrong?
Congressman, unfortunately, given that that matter is in litigation, I can't really speak to the specifics of that. I think you will see in our written testimony, in my oral statement, some of the factors that borrowers have had to navigate in order to become eligible for forgiveness under both public service loan forgiveness and its temporary expansion. And some of that has to do with the limited availability of benefits to the direct loan program. And in order to access the benefits via that route, some of the additional steps that borrowers have to take to do that.
As you listen to her story, though, which I think probably is not unique, were there any thoughts that you had that perhaps more could have been done over the years to address those concerns?
So I think the department has, over the last several years, taking an increasing number of steps that we at Federal Student Aid have to increase our outreach in terms of trying to help borrowers understand what the requirements are and what they need to do to access the benefits. We're trying to use to a large degree, social media, so we can try to reach as broad an audience as we can using the most current communication tools and methods. One of the new tools that we're excited about and think will be very helpful to assist borrowers navigate some of the complexities involved is the new Public Service Loan Forgiveness Help Tool. And that's something that we're making available on our website and are trying to promote and make others aware so that they can make sure borrowers have that in order to use. It really is a very useful tool.
Thank you. And are you saying that this tool is available today?
Yes.
And are the instructions for using it clear as a bell?
Congressman, I believe they are.
Have you tested it on students?
It has been user tested. And we're seeing
how many students?
The test, in terms of user testing, I don't know what the size of the focus groups were or the user testing. We do know that it's already been used in the first half of this year, almost 250,000 times, and generated, as I mentioned before, the importance of the employment certification form, over 82,000.
I understand that you're often pointing to the Next Gen program. How far along is that?
So the department has taken a critical first step towards that with the award.
Is that a baby step or a first step?
I think it's a significant first step. It's the digital customer care solution, which is going to consolidate multiple websites on the department now that are student-facing. It'll be our way of being able to promote FSA as a single brand and have a single point of entry for borrowers, students, and families to receive more information about student aid.
Okay.
And we'll be able to streamline and make more consistent our communication and outreach.
And that will be dependent also on people complying with a bid package as you go forward. Okay. Ms. Emery Iris, could you give us a sense, if you will? I mean, you've been working with this for a long time. I get the feeling that in looking at all this, even though the department has said they're taking steps, they're working on it, many of the recommendations have been very slow.
Right.
Would you attribute that to being lukewarm to this program, or do you think that they're committed?
I can't comment on that issue, but I would say that several years ago, we pointed out problems in terms of the financial incentives for servicers to talk about PSLF, and actually pointed out that there was a financial disincentive for servicers to counsel borrowers about PSLF or about loan consolidation because they would lose those accounts. Those accounts would go to another servicer. We pointed that out. We made a recommendation to the department years ago to address that issue. That remains an unimplemented recommendation. We also made recommendations last year to do things like have a single manual for the servicer to make sure that the servicer knew what the guidance was for the program. That has yet to be implemented. There's a lot of stuff that can be done at the ground level right now to fix this program, and we think those things should be done.
And do you have, give us a sense, you think they're going to be done? When do you think they're going to be done?
I would defer to the department on that. We've been told that by and large, 2020 is the date for a lot of the activity. I don't know if Mr. Appel would like to add anything further on that.
Would you confirm that?
Some of the recommendations that Ms. Emery Harris mentioned that the FSA, the department, has agreed to do include developing a servicing manual, which we are planning to do by spring of next year of 2020.
All right, we'll follow up. Thank you, Mr. Pell, Ms. Emery Harris as well. I want to remind my colleagues that pursuant to committee practice, materials for submission for the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing, preferably in Microsoft Word format. The material submitted must address the subject matter of the hearing, and only a member of the committee or an invited witness may submit materials for inclusion in the hearing record. Documents are limited to 50 pages each. Documents longer than 50 pages will be incorporated into the record via an internet link that you must provide to the committee clerk within the required time frame, and recognizing that that link may no longer work after a number of years. I want to again thank the witnesses for their participation, and you know, what we've heard is very valuable. I have to say that there is some disappointment, obviously. I don't know, Mr. Appel, whether you feel that it would have been good to have FIA here for this hearing, that in fact, despite the fact that they adhere to regulations, obviously the law that Congress sent, nevertheless, we would have gained some insights, I think, and perhaps the Department of Ed would have been in that position as well. I think that we all would like to see more transparency in this regard. That hasn't existed. And only with the push of GAO, I think we've been able to really acknowledge the fact that there are real problems in this. They've been there for a long time, and we're concerned that they haven't been addressed. Yes, and I will recognize the ranking member for his closing statement, but it's been perplexing. And I hope certainly the next time that we meet, we all want to solve this problem. And I think y'all do too. But there's been problems in trying to get to that point. Mr. Smucker.
Thank you, Madam Chair. And before I make those closing remarks, with your permission, I'd like to submit for the record a letter from NATSFA, which details the student and administrators' long concerns with the implementation of PSLF over multiple administration and includes recommendations to Congress for how to legislatively fix the program to help borrowers. So I'd like to submit that for the record, if I may.
Oh, yes, I'm sorry.
That's okay.
So ordered.
The staff has the actual report. Thank you. Thank you, and I would like to just close by thanking each of you for being here, for thanking the witnesses from both panels. I think we did hear a lot today. We learned a lot. I drew just a few conclusions from the conversation that we've had today. One is this was a law that created expectations which were far beyond what was laid out in the law. The law was more complicated than borrowers were led to believe, and it led to some unfortunate circumstances where borrowers did expect a benefit that they were not able to access. So I think the first takeaway for me is that we as members of Congress have an obligation to write laws that are clear, laws that are written simply and clearly, and I think there was a failure in this case for that to occur. And then that legislation must be faithfully carried out. It's a duty by the administration, all administrations, to carry out the intent of, or the legislation that was passed by the administration. And I think in this case, there was a failure there as well. I think and it's unfortunate, the executive branch from the beginning fell short of providing borrowers the information that they needed to verify whether they were eligible, first of all, and then to start down that pathway to eligibility. The department failed as well, I think, from the beginning, from 2007, to inform the entities that were carrying out the PSLF, to inform them of what precisely they should be telling borrowers, what information that they should make available. The department failed to notify borrowers that although they met some conditions for PSLF, that they perhaps were working for a nonprofit, there were many other conditions that needed to be met as well. They may have had the wrong type of loan, they may have been in the wrong repayment plan, they may have been working for a non-qualifying employer, or they maybe, as was mentioned, hadn't been in repayment long enough for that 10-year period to qualify for forgiveness. But again, all of that is only part of the problem. As we said earlier today, the Secretary must follow the letter of the law. That is her constitutional duty. And any accusations that she is doing otherwise or can even do anything else are just absolutely false. It is the responsibility of Congress, of all of us here today, not loan servicers, not the department, to fix a program that has clearly been overpromised and underdelivered. Republicans on this committee stand ready to discuss bipartisan solutions to provide relief to deserving borrowers struggling with student loan debt. I urge my colleagues on the other side of the aisle to drop this quest for scapegoats, realize that Congress created the PSLF mess, and come to the table with us to do what is right for borrowers across the country. Thank you, Madam Chair.
Thank you. I want to ask unanimous consent to submit for the record a letter from the bipartisan PSLF caucus, the PSLF caucus, expressing their support for the program, and also a statement from Representative John Sarbanes on the PSLF program as well. And since it's in my responsibility to also say without objection, we're submitting that for the record. And I basically, given you my sense of this, I think that despite the fact that I think we all are saying we want to work on this problem, there is a need to acknowledge where some of the failure has occurred and then to move forward. And I think that's what we are here to do today. It is disappointing to hear from so many young people that are out there that all they want to do is really serve their communities. They want to be teachers. They want to be able to provide for their community's health and emergency services, whatever that may be. And clearly, despite all perhaps best intents, we have not lived up to the promises of what this legislation had hoped to do. So we have work to do. I think you all have work to do. I know the department also has work to do. I hope you would acknowledge that. And we'll try and get on with that and be back and take another look at this next year. Thank you very much.
Thank you, Chairwoman. Thank you, Mr. Rankin.